number supplementary item 56. Would it be possible to accommodate me at 2 o'clock, my lord? Because it is down below. Possibility of releasing is rather than today.
The matter pertains to that one.
Right, blacklisting.
Blacklisting.
Yeah,
Okay.
obviously.
It has come up for orders.
Yes,
Or
ma'am.
what?
We have served the notice and we have filed the affidavit for service of notice now.
Orders.
Yes. Must have.
See.
Wait, Mr. Lordship. Lordship, item number 48, Lordship, we have filed an additional affidavit also. What can you work with us?
Yeah, please, Lordship. My lord, I beg to mention for listing in motion after Diwali, my lord. Pertain
For what?
for motion, my lord. For motion, my lord.
Promotion of?
My lord, for motion after Diwali, my lord.
Promotion of what?
For motion, my lord, for writ petition, my lord. Matters pertaining, my lord, land acquisition, my lord, case. It was filed on, my lord, 29/8/2025.
It is pertaining to
Land acquisition, my lord.
land acquisition. Isn't it bench 4? Bench 5?
Bench 5. Sorry, my lord.
May it please your lordships. My lord, may I pray for listing of a writ petition on Wednesday, my lord?
Why?
I am a fair price shop owner. My lord, without giving me any opportunity, they have suspended my license. On 20th, they have issued a show cause notice, and on 20th itself, they have suspended my license. Wednesday, my lord.
24th?
I'm deeply oppressed.
May I please, Lordship? Lordship, item number 55, supplementary item. May I kindly be adjourned for the day only, Lordship?
Five. You are for the petitioner?
Yes, Lordship.
There's some office note fixed. We'll see why the matter is emerging. It appears when the matter is being called for, list the matter on 15/12/2025.
On motion item 1.
Yeah, please, your lordship. Lordship, as per the direction of this honorable court, lordship will file an additional affidavit. Lordship may kindly have a look. It's page number 71 of the additional affidavit, lordship. That is instruction to the bidder, lordship, 34.2, lordship.
So you were issued a letter of acceptance.
So, yes, lordship, I have lordship, lordship may kindly come to annexure number B 143, lordship.
Each?
143 page number of my additional affidavit, lordship. Bank has issued a certificate, lordship, saying that the TDR itself is an FDR.
No, understood. Why have you filed this case?
Lordship, because initially,
Mr. Bachaji, remember, I don't read the file and come. If you are not in a position to argue, don't argue.
lordship,
We'll have it on some other day.
lordship, lordship.
At the request of the learned counsel for the petitioner, matter to be listed after 6 weeks.
3 weeks, lordship. 3 weeks.
6 weeks.
Diploma. Lordship, the matter pertains to non-payment of admitted contractual dues, your lordship, of the husband, deceased husband of the petitioner. Husband of the petitioner died in 2024, your lordship. Thereafter, he has served a legal notice, redress notice, and thereafter there is an admission on the part of the executive engineer PWD about the dues that are remaining to be paid, your lordship.
So what is this? These are contracts pertaining to the year 2002, 2003,
Lordship.
huh?
Lordship, there are
1992. What is
Several-
this?
several contracts, Your Lordship. There
So-
are several contracts. Some bills are partly paid, Your Lordship.
No,
and
partly paid or not paid. What is this? You wake up one fine morning after so many years. You cannot do this.
Lordship, this is the
This is
wife
not
of
the
the,
way how you file a writ petition. You get one communication or make an RTI after a long time and then they come up, there is no admission of the dues. Where is the admission of the
Lordship,
dues?
page 22, Your Lordship.
Where is the admission?
Page 22, Your Lordship.
Page?
22, the last
Okay.
page, Your Lordship.
Yes, what is it?
The total outstanding dues as per our office record is so and so, Your Lordship. This is a letter in response of a previous notice by the,
How will they find out?
they have given a list. as
Mr.
well.
Gogoi, tell me, how is it possible? And why is the engineers doing all these things? Now, whatever may be BTC, non-BTC and all these things, huh? How can these people verify this amount? This is done in the year 1992, 93, 1999. You issue one on 4/11/2024, you issue a legal notice and they give a reply. Matter over. What happens as regards these amounts were due at in 1992, 93, 94?
Lordship, the
Then,
only thing is the petitioner is the wife of the deceased
so what?
contractor, Your Lordship.
He, during the lifetime of his husband didn't want the money and now you are asking for the money. No thanks. I'm not issuing notice, I'm dismissing it
Lordship,
right away.
if I may get some time to see whether there are interim documents, Your Lordship.
Interim documents, there is no acknowledgement. This acknowledgement would have no relevance.
Because there are part
Why is
payments,
this executive engineer PWD issuing this type of documents? Admission.
No, this is not an admission, RTI, man, they have sought for under the particular statute.
No, this is not an RTI. This is a reply under section 80.
Yes,
Kindly see.
yes, legal notice.
As per section 19 of the Limitation Act, if the period expires, then you don't get the benefit. Then how is these people are doing all these things? I'm not issuing notice in this
Lordship,
case. I'm dismissing it right away.
at least, Your Lordship,
Go
sometimes.
before
so
the
that-
civil court. You have an admission, go before the civil court.
Lordship, at least sometimes so that I can verify whether
Verify for what?
there is any part payment, recent part payment of this.
Recent part payment. This is what has been mentioned. You have not mentioned a single thing about the part payment or anything.
Lordship, because
Even
the,
in your legal notice also, you have not mentioned that my husband so and so executed several works in his lifetime. The following works were there. That in pursuance to the aforementioned term, my client husband duly completed the works allotted to him in time. That means in 1992, 93 he completed. Till date, not cleared the outstanding dues after completion of work.
Lordship,
Then
because she does not have all the documents, the completion certificates and
what?
everything, Lordship.
for this code, therefore, how will these the authorities verify of 1992, 93 aspect? And the best part is this. The legal notice says 52 lakhs and the reply gives here are 53 lakhs. Can there be anybody better, more benevolent people? I'm not issuing notice. This is a case for dismissal. Go
Lordship,
before the civil court.
Lordship, some time for at
No.
least some certain instructions, Your Lordship. I can withdraw if there is a liberty, Your Lordship, for
Go before the civil court.
appropriate forum. Lordship, I can seek instruction for withdrawal in that regard, Your Lordship. Next week.
I'm
it is-
dismissing it. No instructions for withdrawal. I'm dismissing it right away. You cannot wake up one fine morning. Person died when?
2024, Your Lordship.
Then after during his lifetime, he never sought for anything.
Lordship,
June 22.
Huh?
June 20.
June 22. June 24.
So
There
June
is no
2024, the moment he died, thereafter you woke up.
Lordship, there may be certain documents, Lordship. That's why I'm seeking for
So,
some.
There's
But
nothing mentioned out there.
The wife does not have all the documents ready with her. That's
If he doesn't afford this court to make this inquiry,
Lordship,
go
for
before the civil court. You withdraw and go before the civil court. Or if I say that, I'll have to say that this is two belated claims. This
Lordship,
cannot be.
I withdraw with the liberty to approach the civil court.
Mr. B. Mukherjee, the learned counsel appearing on behalf of the petitioner. Heard Mr. B. Mukherjee, the learned counsel appearing on behalf of the petitioner. And Mr. B. Gogoi appears on behalf of the PWD department, and Mr. also appears on behalf of the BTC. BTC, na? The learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to approach the civil court rather than pursuing the litigation before this court. Taking into account the above, the instant with petition stands closed on withdrawal. Liberty, however, would be there upon the petitioner to approach the civil court
As per law, but
as per law,
Item 3.
if permissible under law.
May I please your lordship? Lordship, the petitioners here in a running to a hotel under Golpara Municipal Board, lordship. And the said hotel has been run by their father. Since 1995, they are running that hotel. And in the year 2012, a fire broke out and the petitioners saw hotel and it's as well as 18 other numbers of shops got burnt. So thereafter, a meeting was held between the shop owners and the Golpara Municipal Board. And in
Why are you approaching after 13 years?
no, they have allotted me.
Then what do you want?
They have allotted me, and in the meeting dated 4/9/2012,
Where is that?
it was page 32.
Eight?
Page 32. Page 32, it was a meeting on 4/9/2012. Resolution number 2 at page 33.
While taking note of the financial money of the deal, without the fixed to protect others the maximum amount in which if further unanimously resolved with the registration fee on. Yes, then
They took a resolution to allot us shops and the ground floor. But after construction of the building, we came to know that ground floor has been earmarked for car parking. So therefore, we agreed for first floor. And they have assured that if the ground floor is at any time construction is done, then we will be entitled for ground floor. So accordingly, we have accepted their allotment and we have been allotted on 14/12/2015,
when
page 54.
allotment.
Page 54, third
So you
paragraph.
filed some repetition earlier.
Yes, they had not allotted us the shops and construction was delayed. So therefore, some repetitions will file.
So they have given it.
So they have allotted us, and after allotment, we faced
This is only to one of the petitioners,
one of the petitioners,
not the others.
not the others. But the original shop was in the name of their father. So therefore, all the brothers have joined this. So after allotment of this shop, we used to run our hotel at the first floor, but we faced several difficulties. So therefore, all the shop owners submitted several representations before the municipal board that we may be allowed shops and the ground floor.
Ground floor is parking.
Ground floor is parking. They were saying the ground floor is parking, but cars were not parked at that moment. So we say, thereafter, in the year 2022, they started construction over the ground floor. So we filed an representation before the municipal board, which is at page 67. So since constructions are going on in the ground floor, so as per the original resolution of 2012, we may be allotted shop in the ground floor. They did not act upon this representation. So we approach this honorable court. We approach this honorable court that either ground floor may be allotted to us or it may be earmarked for parking.
So there is one writ petition pending.
Yes, one writ petition is pending by the other shop owners. So in the said writ petition, this honorable court has status quo has been passed, and page 75 is the operative portion.
Then, but you accepted this
Yes,
pursuant to an order being passed by this court.
pursuant to order passed by this honorable
What is the
court,
order passed? On the
Order-
basis of issuing notice here.
Page 47.
Pending discharge status quo here.
page 47 is that order,
Yes.
15/10/2015.
Pending notice is ordered that in the event the AI initiates process for allotment of the same shall be done having regard to the resolutions adopted so and so. So accordingly, these two resolutions and you have accepted it.
Yes,
Then
As
why
per-
can you,
as per the resolution of
now
49
why you are going back? You have
Yes.
accepted this allotment letter?
Yes, we have accepted this allotment on the pretext that ground floor will be reserved for parking.
Hmm.
But now they have started construction over the ground floor to allot the same to other persons.
Hmm.
So other shop owners have already filed their petition before this honorable court, and status quo order has been granted. I have also annexed some photographs at page 76.
Then
So this construction is going on.
Hmm.
So as per resolution of 2012, I am entitled for ground floor. And on the pretext that ground floor will be earmarked for the car parking, only that apprehension, I have taken that my shop at first floor. So now they are coming with some construction to allot the ground floor to some other persons. So as per the resolution of 2012,
well, resolution is long over.
long over, but
Accepted it.
they cannot shy away from that
You have
resolution.
waived it.
No, Lordship, but in my allotment letter also, it is written, seen and peruse the Honorable High Court order dated so and so, as well as minutes of the tripartite meeting of 7/8/2012 and 4/9/2012. Kindly see the
And the meeting of so and so and so and so.
so and so and so and so.
So and so, I have gone through all the records, we have made it clear that the ground so and so where G+2 commercial has been newly found that so and so has deposited so and so have duly entered into an agreement for rent with certain terms and having perused the so and the newly constructed demand, when monthly rent has been added so and so, it's the demand and the per therefore payment is directed to take possession of the allotted room from player concerned with the 7. Oh,
So
matter over,
as
you are
per,
waived.
as per 4/9/2012,
Hmm.
we were supposed to allot shops at the ground floor.
Understood, but you have waived.
But they, on the pretext that ground floor will be earmarked for parking.
But why did you accept this allotment letter?
But because at that moment, ground floor was earmarked for parking.
So,
But now they have started construction.
by this way, you have waived yourself in
Lordship,
2015.
I
After
am-
10 years, now you want in the ground floor. You
Uh,
cannot have that.
at that time, they had said that ground floor is earmarked for parking. But now they have started construction. So since they have allotted the shop as per resolution of 4/9/2012, as per 4/9/2012, I am entitled for ground floor.
No,
So
no,
then
no.
if
Then
they are,
there is a novation by which in 2015 there is another meeting.
yes, Lordship, there is
Then
a-
on the basis thereof you have been given in 14/12/2015.
but in the same allotment letter, 4/9/2012 has also been.
So what? But you have already accepted it.
But
There's
my-
a bipartite
but-
meeting on 1910 and 9/11.
But my original meeting and original allotments as per 2012 and
I think we should get hold of the other case and dismiss both of them together.
Lordship, since now they are playing with us that one time they have said that
But tell me, your allotment order was only for 3 years.
no, they have accepted.
Where is your extension?
They are accepting my
Your extension.
no. They are receiving.
You don't have a locus.
No, they are
You
receiving.
don't have a locus.
No,
Still
Lordship.
be.
I have categorically stated at paragraph 31.
No, so what?
They are. I am
Come to
regularly.
paragraph
I am
54.
regularly paying I am regularly paying the rents,
So what? They are accepting it by grace. You are a tenant by?
but they have not issued any
What is it?
eviction notice also.
The tenant by?
They have not issued any eviction notice also. So my humble submission is that
You don't
so
have any right.
if they are constructing in that area, ground floor area, so that area may be given to me.
No. That is too long. You have already waived.
My relation back is in 2012 resolution will be there, Lordship.
So there is already a stay order there.
Lordship. Other persons who are 18 persons
So
who have
you
been-
want a similar order.
Lordship.
But I am not going to grant a stay. There is already a status quo given.
So status quo in respect of my shop is not there, Lordship.
There is status quo for everybody. Status quo as on today regarding possession of
Possession
shop
on
in
the
the
ground
ground floor. So everything is stopped.
So that
So
will
we
get
issue notice and fix it along with that.
Lordship.
That's all. This is not a case, case. Issue notice, making it returnable on. So let me dismiss both together, na? Pull up the other one and dismiss it. Returnable on 8th of December 2025. Mr. G. Bukel accepts notice on behalf of the respondent numbers 1 to 3. Extra copies of the writ petition be furnished upon him during the course of the day. As regards the respondent number 4 and 5, the petitioner is directed to take steps by way of speed post by tomorrow, by Monday. In addition to that, the petitioner
Monday.
is also directed to effect service upon the respondent number 4 and 5 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioners herein is that they were originally shopkeepers, temporary shopkeepers. But pursuant to resolutions dated 7/8/2012 and
4/9/2012.
4/9/2012, it was decided in the said minutes that the shopkeepers, including the petitioners, would be given allotment in the ground floor, subject to payment of necessary fees. Pursuant thereto, there was a move on the part of the respondent number 4 and 5 to keep the ground floor vacant for car parking. And the shops were to be constructed on the first floor and above. After the construction, as allotments were not made, the petitioner approached this court by filing a writ petition, which was registered and numbered as
6401/2015.
6401/2022.
15.
Where is your name?
As if 17 others.
The petitioner, along with 16 others, had approached this court by filing a writ petition being registered and numbered as WPC number 6401/2015. Pursuant thereto, there were two meetings held on 19/10/2015 and 19/11/2015. And in pursuance thereto, 9/11/2015. And in pursuance thereto, the petitioner was, one of the petitioners, that is the petitioner number 1, was granted the allotment or issued an allotment order on 14/12/2015 in the first floor of the building. It is the case of the petitioner that subsequent thereto, the the subsequent thereto in the year 2022. Steps have been taken for construction on the ground floor. And as such, similarly situated persons, like the petitioner, has approached this court and filed a writ petition dated bearing number being
296.
registered as WPC number 2960/2022, whereby seeking redressal of their grievance that they have not been accommodated in the ground floor. The learned counsel, appearing on behalf of the petitioner, submits that this court, by an order dated 9/5/2022, had issued notice in WPC number 2960/2022 and further passed a status quo order. It is also the submission of the learned counsel that the said status quo order still exists. Taking into account that the learned coordinate bench has already passed the status quo order, it is the opinion of this court that there is no requirement of any fresh interim orders in the instant proceedings. Be that as it may, it is the opinion of this court that the instant writ petition be disposed of along with WPC number 2960/2022. As the matters raises identical questions of law and fact. Accordingly, WPC number 2960/2022 be tagged along with the present writ petition on the next date by the registry. The respondents herein are directed to bring on record their stand by filing the affidavits. Issue notice. 8/11, 8/12, 8 by affidavits on or before 1st of December 2025. Liberty given to the petitioner to reply if so any.
Item 4.
What is this?
Supplying of electricity connection. The supply will electricity connection, my lord. Petitioner purchased one flat, my lord, but he had some dispute with the owner, my lord. So owner disconnected the electricity connection of the flat.
You are the owner of the flat.
No, I'm not, I purchased it. Original owner was, my lord, a private respondent. I purchased the flat. I executed one registered agreement for sale. Thereafter, I made all the payment, my lord.
No. Sold it. Done or not?
No sale.
Then how did you purchase?
No, agreement for sale was. done.
Agreement for sale, does it mention about the purchase? Can there be a purchase by way of an agreement for sale?
No, in the agreement for sale, it was mentioned. My lord, I'm just,
Are you a tenant?
not tenant, my lord.
Then
No, I have taken possession. Only I'm basically. As per the agreement for sale, my lord, if I pay 18 lakhs to the landowner, the owner of the flat, he was supposed to hand over me the possession. And the possession was handed over, and later on some dispute arose, and thereafter he did not execute the final sale deed. My lord, now I am in possession of the flat. I have also paid all the money that was due to the bank. I have all cleared all the payment, my lord. Now all
so
payment.
go before a civil court.
In the civil court, we have filed a case for specific purpose
Specific
of
performance. File an IA there. What is this court going to do? File an IA that the electricity connection has been disconnected. Usually it is required. So file an IA, get a connection from them. They also provide the connection. Because this court cannot tell you, the moment I pass an order out here, it will have an impact on the civil litigation. Isn't it, Mr. Sharma? Yeah, that is his submission.
My lord, actually, as per section 43, my lord, they are required supply. As per section 43, my lord.
Oh, approach. They will give it. Yes, my lord. You give a temporary meter, no?
The temporary connection is given.
No, fantastic.
Temporary,
You want a permanent connection.
temporary is given. But
How can a permanent connection be given unless you get a specific performance of the decree? Tell me.
Now, here, my lord, as per,
As per 4.3, he has to supply all those essential documents, also, and he's not even a tenant.
No, he can very well get a connection. You are having a connection now.
temporary connection I am having, my lord.
So you continue to have it unless you get the specific performance. You cannot be given a permanent connection because you are not the owner of the house till now.
Now, as per section 43, my lord, it doesn't say owner, my lord, it's section 43, my lord.
What does he say?
My lord, I'm reading, my lord. Save as otherwise provided in this act, every distribution licensee shall and on application by the owner or occupier of any premises, let's say occupier, give supply of electricity to such premises within 1 month after receipt of the application required.
So they are giving you the connection, the
No, no.
electricity.
Here, they're giving temporary connection. means
How can there be a permanent connection being given to you? Tell me.
my lord,
Tomorrow, if you lose the case, what will happen to the connection?
my lord,
You-
their connection will be disconnected, my lord.
Now go before the civil court, get an injunction, apply, file an high, they may give you. They
Then-
won't disconnect, they will keep on until you
We are
pay.
already supplying temporary.
Huh?
Already temporary connection has been supplied.
Actually, in temporary connection, actually, a huge fees is collected, my lord. The amount of money taken is actually a huge amount, my lord. For temporary connection, actually. It
Temporary
is not
connection is higher, so therefore.
higher, it is
But can this court direct permanent connection? Tell me.
nearly about, I think, my son is about 20,000 he has to pay per, about 20,000 he has to pay per month. Per month, man. That is the problem, my lord. For temporary connection. Yeah, my lord, here say occupier, actually, my lord, that is why, and owner or occupier, my lord, actually, is section 43.
You filed a suit recently.
Yes, my lord,
Yeah.
Annex 3, my lord.
No, this court cannot happen. And all along, you were handed over the possession in the month of when?
December, I think.
And when was it disconnected?
February, I think. February, on 6/2/2025.
No,
Yes, six.
no, you were handed over the possession in the month of August 2024.
Yes, yes, para 5, I think.
Then,
Para 5. Thereafter, my lord, on 6/2/25, this connection was disconnected. 6/2/25, my lord.
then
My lord, we approached the civil court for specific performance of contract and.
you
but-
filed application before the civil court.
but then
better off.
observation may be made, ma'am.
It has been heard, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. S.P. Sharma, who appears on behalf of the APTCL. Pusto. The learned counsel appearing on behalf of the petitioner submits that there is already a suit being title suit number 434/2025 pending before the court of the civil judge senior division number 2 Kamluk Metro at Guwahati, seeking specific performance of the agreement dated. Agreement dated
Uh,
Agreement dated
I-
12/7/2024.
12/7/2020.
And full stop. Taking into account the above, comma, the petitioner herein is given the liberty to file appropriate application before the trial, before the said court, seeking appropriate directions upon the APDCL for providing electricity connection.
Yeah, actually, man,
Writ petition stand.
we just senior division, actually, there is no code actually at present.
Huh?
At present, there is no code. No one is there, man. The land has been transferred, man. That is the problem.
Mr. Counsel,
Yeah, oh, look,
if I am to advise you, you want to file an application, you can very well file an application as per the Bengal Agra Assam Civil Courts Act. If an urgent application is moved and if that court is not there, that application would be moved before the district judge. The district judge will allot it to
Yes.
another judge.
right.
Oh, yes. You got the order yesterday.
Yes, my lord. Obliged, my lord. Here, my lord, in
Yes.
respect of package number, serial number 1, my lord, he had not issued the certificate, my lord. Yeah, the package number 1, my lord, in the writ petition, my lord.
In this petition.
Yes, my lord. There are 3 packages, my lord. In package number 1, my lord, they had not issued certificate, my lord, and here submitted the bid, my lord. And at serial number 2, my lord, the petitioner, the certificate was issued, my lord.
No, we are, no, here we are concerned with one writ petition.
Yes, my lord. The package, the certificate was sought for 3 packages, my lord.
And then
Common, my lord. They had issued against only 1, my lord.
last date for submission of the bid, site verification signed with the executive engineer on 25/7. Tender opened, participated in the area, but the tender was cancelled and was the simple participation in the tender. But here it is, this tender number 2 was cancelled.
Yes, no, not tender, my lord, package. In
The-
one
the-
tender, there
That
is a-
package is cancelled.
there is
You are
only
going
one
to go for a
bidder.
fresh tender. So that is no problem. As regards one and the
1 and 3, my lord,
1 and 3, you have not finalized till now.
technical will not finalize.
Now,
Yes,
so
submitted.
as you have issued the site verification certificate, consider those
I
two.
will serve a copy to him. I will serve a copy to him today itself.
No, I passed the same order.
My lord.
Otherwise, Lordship may kindly see, my lord, in July 28 was the last date of submission of bid. He remained silent, my lord, for last 3 months. Suddenly,
No, they want the stay there. I'm not going to pass you a stay order. So, hey, আগৰ কালি order টো যে আছে, এটা copy এটা ওলাওকচোন। পাব নেকি?
WPC,
I just 13, my lord.
WPC number, my lord.
13, 15 and 16.
Yesterday I passed an order. I think the same orders can be passed
Yes,
there.
593, WPC number 5930 of 25, my lord. 5930, WPC number.
Heard Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner, Mr. B. Gogoi appears on behalf, the learned additional advocate general as well as the standing counsel of the PWD, except appears on behalf of all the respondents. Full stop. The petitioner herein is aggrieved by the action on the part of the respondent number 3 in not issuing the site visit certificate, for which the petitioner had to submit his bid without the site visit certificate. Full stop. The materials on report show that the respondent authorities have issued a notice, have issued an invitation for bid for carrying out for 152 numbers of packages for construction of roads under Mukhyamantri Pakipad Nirman Asoni, bracket MMEPNA, bracket close under RIDF dash Roman 31 of NABARD for the year 2025-26 in Bozali, Borpeta, Kachar, Dorong, Dhemaji, Dibrugarh, Goalpara, Gulaghat, Jorhat, Kamrup, Kamrup Metro, Lakhimpur, Majuli, Nagaon, Nalbari, Punitpur, and Tinsukia district. The present petition. In the present petition, the petitioner is concerned with the packages, numbers,
My lord, 141, my lord.
Huh?
Your lordship will find it 141, my lord. Serial number 141.
package number,
Page number, my lord, 45, my lord.
package at
Number
serial
140
number
141.
141, 142, and
143, my lord.
Huh?
143, my lord.
143 also, and 143.
Yes, my lord.
Pusto. Taking into account the relevance, the three packages are quoted hereunder. Page 45 or 46 A and A. Apnar a format to the 145, 142, 141, 142, and 143. Pusto. It is relevant to take note of that in terms with the said invitation for bid, which was published on 7/7/2025. The last date for submission of bid was on 28/7/2025. And the bid was supposed to be open on 28/7/2025.
Right.
As per the tender condition, more particularly clause number 7. Huh?
7-1, my lord.
7. I remember.
Yes,
Clause
7.
number 7. There is a requirement of the bidder to obtain a bidder at its own responsibility and risk to visit and examine the site of work and its surroundings and obtain all information that may be necessary for preparing the bid and entering into a contract for construction of the works. This site visit certificate has to be verified from the concerned engineer in authenticating the visit to the site works, and the same is required to be submitted along with the bid. The materials on record show that the petitioner duly visited the said site. The three sites in respect to packages numbers 141 at serial number 141, 142, and 143.
Right.
And this aspect is further verified, further certified by the Assistant Executive Engineer PWRD by the communication dated 25/7/2025. It is the case of the petitioner that in spite of the site visit being made, that too, in presence of the Assistant Executive Engineer PWRD,
Yes.
the respondent number 3 have not issued the site visit certificate. Resultantly, the petitioner submitting his bid without the said 3 certificates. Without the site visit certificates. When the matter has been taken up, at the motion stage, Mr. P. Gogoi, the learned standing counsel of the PWD, placed before this court a set of instructions. The said instructions are record and mark the letter X. From the said instructions, it appears that in respect to all the three packages, that is at serial number 141, 142, and 143. In respect to packages at serial number 141 and 143, the site verification certificate was issued on 25/7/2025 itself. But the petitioner did not take it from the office. However, as regards the package at serial number 142, the site verification certificate was taken by the contractor, by the petitioner. Full stop. The instructions further show that as regards the package number 142, the same at serial number 142, the same have been cancelled, taking into account that the petitioner was only the single bidder. Whereas, on the other hand, in respect to packages at serial number 141 and 143, the technical bids have been opened, but the same have not yet been finalized. First. Considering the above, that the site visit certificates in respect to package number at serial number 141 and 143 have been duly issued by the concerned engineer on 25/7/2025, as stated by the respondent. It is the opinion of this court that the respondent authorities are required to take into account the said site visit certificates dated 25/7/2025 in respect to packages number 141 at serial number 141 and 143, while considering the technical bid of the petitioner. Next. Accordingly, the instant petition stands disposed of with the following observations and directions. Number one, the respondent authorities jointly and severely are directed to take into account that the petitioner have been issued a site visit certificate on 25/7/2025 in respect to packages at serial number 141 and 143.
My lord, 143, my lord, petitioner did not submit, my lord. Did.
Huh?
Only 141 we submitted and 142 submit.
You only submitted in 141 and 142.
My lord. Yes. Yes, my lord.
But I'll get a line like
143.
and applied for engineering. Not been opened. It is also being stated by Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner, that the petitioner did not submit the bid in respect to
Package number
the
140.
package at serial number 143.
Yes, my lord.
Mr. Hawk, why on earth, if you have not submitted, have filed the writ petition?
My lord, there was some confusion, my lord, for my part also, my lord. Actually, my lord,
Whatever you feel like you do, na?
no, my lord. I am really sorry, my lord.
No, I'm allowing this repetition with this observation, but with a cost upon
My-
you. Upon you.
My lord,
Of 1 lakh.
I'll be cautious, my lord.
No, 1 lakh.
No, my
Because
lord.
this is what you are doing. 1 lakh
No.
with the cost. No.
My lord, kindly.
No, you cannot keep on doing like this.
No, I am.
Why on earth have you mentioned about serial number 143 when you have not submitted the
My lord,
bid?
143, my lord, they have not issued the certificate because already two packages here already submitted.
Then why have you mentioned about 143?
My lord,
Then why not others also? We put all 152 packages.
no, my lord, particularly, my lord, here they applied against three packages, my lord. certificate.
what?
It is certificate.
So what? But you have not submitted for 143.
My lord, the
What do you want? The cancellation of the bid tender?
No.
Then why have you mentioned about
That
143?
is why my lord, I am pointing out, my lord, before your lordship, my lord.
আপনি আপনার ঠিক করবো বলে at serial number 142. Also taking into account the above, this court therefore disposes of the accordingly the instant repetition stands disposed of with the following observations and the respondent authority jointly and severely are directed to take into account that the petitioner have been issued a site visit certificate on 25/7/2025 in respect to the package at serial number 141. Houston. There is no necessity of 140. It is number 2. It is observed that as the petitioner had not submitted the bid in respect to the package at serial number 143, the petitioner has no cause of action in the instant proceedings. Number 3. The above directions so passed are only in respect to issuance and consideration of the site visit certificate. And this course has, however, otherwise not mentioned anything about the eligibility of the petitioner in respect to the tender process.
No.
Who's next? Mr. B. Gogoi, the learned standing counsel appearing on behalf of the respondents shall instruct the respondents about the instant order so passed. And the court master of this court is also directed to provide a copy of this order during the course of the day to Mr. B. Gogoi, the learned standing counsel for the respondents, so that the needful can be done.
My lord, I move.
45.
Right. What is this?
My lord, here in this case, my lord, tender was cancelled on technical reasons, my lord, after opening of the financial bid, my lord.
Huh?
After opening of the financial bid and petitioner successfully stood as L1, my lord.
You are
Technical
L1?
bid- L1, my lord.
There is a contract issued for construction of a model secondary school.
Yes, my lord, balance
Then
work
what
for
happened?
construction. Balance work for construction of model secondary school in tea garden areas.
And then you applied.
I have submitted my bid, my lord, and
Then what happened?
then my technical
What is
bid
your
was,
name?
technical bid was responsive, my lord.
Imami Construction. What is your name?
Empire Infra Project.
Empire Infra Projects. Empire Infra Projects. Okay. You are
Your lordship, may
admitted.
page
So there
35,
were 2 persons who have qualified in the technical bid.
my lord.
Okay, then what happened?
And financial bid open, my lord, your lordship may found it at page, my lord,
40.
page 40, my lord.
Okay, then. So you quoted how much?
Infra, Empire Infra Project, my lord,
Do you quoted 2 crores 51 lakhs 84,400? How much? 25 crores?
2 crore 51 lakhs, my lord,
84,400.
439,
Okay, so you are L1.
my lord.
Then what happened?
Then, my lord, my tender was
Page
cancelled.
41, proceed with page 41.
With regard to you are requested to submit a detailed justification regarding the suppression of ongoing work submitted in the technical bid document. For the above mentioned work, the detailed justification should reach the OO, the undersigned within 3 days of the. What is
And
this?
next page, my lord, I have replied this on 16/9/2025. Para 3 is this, my lord.
So
And-
what is this suppression?
Suppression in respect of my lord Janata College, which was allotted to me.
Huh?
But construction of girls hostel for the college, my lord, which was allotted to me, my lord. But site was not handed over. Work is yet to be started. And as per tender document, your lordship, I have also annexed my page 48, your lordship may found. why I have not mentioned this, my lord.
Page,
Page 48, my lord.
existing committee
Description
and
of the workplace of the state, contact number, name and address of the employer, value of the contract, stipulated period of.
Mr. Council, why have you not enclosed the entire document?
Yes, tender condition is not there.
Why?
My
No
lord.
money.
Tender documents.
Why the entire contract document has not been enclosed?
My lord, in that case, I will. submit.
No money. Client did not pay you. No, why? Why on earth have you not enclosed? How do I get to know what it is?
On Wednesday, my lord, I will submit it. Tender to. Through an additional affidavit.
Then what happened? Minutes of the technical bid committee held on so and so, and it has been given to somebody else.
My lord, page 49, your lordship may found. Tender cancellation notice.
Oh.
It is information to all concerned that press notice by letter number such and such, dated such and such for the work mentioned as below is hereby cancelled due to technical reasons. But nothing is been mentioned, my lord. What is the technical reason and why, my lord? Since I have already qualified for in the entire bid process, my lord.
You have suppressed facts. You are the L1.
Yes,
Isn't it?
Exactly, my lord.
yes, L1, my lord, and only 2 bidders were found to be technically viable. If his bid goes, my lord, only 1 remains. So probably for that reason, it has been resent.
That's not true, my lord. Since, my lord, I have already enclosed the copy of the tender document, my lord, wherein, my lord, stipulated period of completion.
Fresh
Since, my lord, work is
issued.
not,
Fresh tender has not been issued.
my lord, press tender already issued, my lord.
When?
Retender on the next day, my lord.
7.
Where-
710, page 51, your lordship, my lord.
Page?
Page 51, 51.
So again participate. Go ahead. Are you barred from participating?
No, my lord, I am not barred from participating, but since, my lord, I have invested huge amount of money and I also relied on.
Why have you invested? Tell me.
Because
And because of that investment, you have not enclosed the entire tender document. Something must be, something to that effect. Because of that investment, you have not enclosed the tender document.
my lord, I have also relied your lordship's judgment that Mahalakshmi Enterprise.
Huh?
Mahalakshmi Enterprise, my lord.
What is that?
Page 54 and 55, your lordship. Regarding the arbitrary exercise of power, my lord.
What is their arbitrariness? You have suppressed facts.
No, my lord, I have not suppressed fact. Since,
You
my
have
lord,
suppressed
work is
facts
yet to
also
be
before
started.
this court also. You have suppressed by not enclosing the tender document. Okay. We have it on Wednesday. You can file the tender document.
No, my lord. On Wednesday, my lord.
List
an
this
additional-
matter, but you can't file it. Today is Friday. Tomorrow is closed. Day after is closed.
Then your lordship, my lord,
When next Friday?
next Friday, my lord.
List the matter on next Friday. In the meantime, an additional affidavit be filed by the liberty given to the petitioner to file an additional affidavit by way of liberty given to the petitioner to bring on record the tender documents, the entire set of the tender documents by filing an additional affidavit.
46.
Before my learned friend starts, item number 42 is similar and we have instruction as per the order of this honorable court with regard to the same contract. Instruction are to be placed in a sealed envelope today, Lordship. That is listed as item
Item
number
number
42.
42 and this similar.
Similar contract, they have challenged the non-intimation of the rejection of technical bid. They also, the other petitioner also came for the similar prayer. This honorable court on last occasion allowed, that is at page number, order is NH, Lordship. Which will come to page
Where?
page 70.
Page?
Lordship. Page 69, Lordship. NH,
This is edifice.
that is item number 42. So they were allowed to participate in the financial bid process. And Lordship, the result will be submitted on a seal envelope, which is.
Having noted this court also noted the petitioner on the last date of submission and process of valid which was now Considering the fact that the field had been eligible on the last date of submission of the bid. As if they had to allow the to participate in the optional bid procedure. Today, this matter is there.
Yes, Lordship.
Okay, we dismiss this writ petition.
Lordship.
This absolutely not, how can this court direct? You did not submit the document, matter finished.
No, I'm not, I'm in 46, the motion matter, Mayor.
Huh?
I'm in the motion matter.
So what? Along with that matter we dismiss. And this also.
So, but my friend has projected a case. I might have it different. I'm absolutely on a bad footing, but I may.
Okay, tell me your case.
My lord. In a particular auction case of demolition of Kacha paper mill, it was required that documents be tenders be
Which
submitted.
paper mill?
Kacha paper mill, my lord.
Oh, now there.
No.
Okay.
Lordship.
What do they want? What happened here?
So we participated,
Hmm.
but it required that the technically qualified bidders, they would sail through and the rest would not be there. So the bidding part would be only for the technically qualified bidders and all. Now the auction date was 13th of October. And I say with all humility, and in September, we had communicated to them through email that kindly let us know our status. This, whether we have technically qualified or not. This is for the reason that unless we know prior in hand, we cannot come to challenge the grounds, good or bad. Now they did not respond. On 9th of October, they did respond by an email that we had told you earlier, kindly check in your email by which we had communicated. 9th of October, Milo, if I take that we had missed the bus.
Yeah.
One view is that we had missed the bus. 9th of October is the date when the last vacation court was on. We are from Kolkata, SPS Steels. So 9th, there was no way we could have filed a writ petition, and 13th, there was the auction. Naturally, 3 other writ petitions were filed in this honorable court. Those 3 assailed.
9th was a vacation bench.
Absolutely.
Then
We were communicated on 9th. So we could not file on 9th from Kolkata. We did not know that they would communicate on 9th. Anyways, they did by a one-liner, which we dispute on affidavit. That you had not sent any email, we dispute on affidavit. Now, when the 3 other writ petitions were moved on 9th, they assailed the communicated grounds of rejection of the bids. Not bid, the documents. They were held to be technically disqualified bidder A, B, C. All of them filed writ petition. 2 of them did not get an interim protection. One, which is the edifice, was given an interim protection.
it is not interim protection, it is as if it has been allowed with due respect to my coordinate bench. Because that allowed.
I was putting it very softly.
Yeah.
Now, the point,
Means on basis that this document was in existing, so
yes,
court took the
the
mantle
parameters which,
of a tendering authority.
my lord, the parameters which weighed for the consideration of the honorable court on 9th, my lord, with all respect, was that since edifice had the document, therefore,
On the basis that it was a pre-existing document.
historical document, it was there. Very well. And what was the benefit given? The benefit given was to the extent of virtually allowing the repetition. I am not against edifice because I'm riding on edifice's interim protection. We missed the auction. So edifice was given on-site inspection and to participate in the auction bid. Here comes the difficulty. The honorable court had directed, we're not challenging it. We're taking advantage of that observation. He says seal cover. Seal cover is a procedure method. I would understand when entire thing, the result of the exercise is not disclosed and it comes to the court in a seal cover. Online auction is such a thing where everyone should know what everyone is bidding. Then only I can bid. There is nothing called seal cover. So all those who are technically qualified, regardless of the fact there's an observation of seal cover, I do not know what their bids are or what they have quoted because I could not.
Seal cover concept does not
Apply to that. Absolutely on that, my lord. Therefore, I say, on one hand, you do not communicate to me the reasons. I put it on affidavit. Whatever consequences to follow, I'll do that. Number 2, you take, an order is passed by this honorable court. The pre-existing document is there. Now, where do I stand? If I want to take.
Okay, let me see your rejection.
My rejection is not communicated to me.
How
If
do
the
you
whole-
know that?
I do not know. I missed the auction. They say we communicated. They do not intimate to me till date the reason.
Now what do you want?
Now, what I say is that you have not communicated me the rejection number one. Had you communicated in time, I would have got the time to challenge. Assuming I could understand that edifice is going on the plank of that certificate, OHA certificate, which they had. Now, I say, if my lord takes up at page 254, I'm banking on, my lord, the case where if the other one is allowed, you cannot leave the another. 254. I say, this certificate I also have, but this is ISO, if lordship comes there, it is ISO 45001-2018 certificate. It is not a certificate which you had asked in the tender. I say I have the certificate. Inadvertently, I could not give it because I had a communication email with you, and the email said,
No, but Mr. Bonik, you did not participate.
no, I participated in the tender. Technical disqualification reasons was not communicated to me, so I could not bid.
Okay,
I am a
so
participant.
the system is, once you are technically qualified, then
Yeah.
you can bid.
Absolutely, I can bid.
Now you submitted your,
Yes, yes.
but you were not informed that you were technically not disqualified.
Not disqualified. On 9th, they communicated to me that
Where
it
is that communication?
my lordships,
Case 68.
68.
68, not the communication, it's the repetition of the communication. We intimated this system generated information on the rejection, which goes by the system itself, Lordship.
Even on,
This is not.
even
done
by the
AI
page 60.
manually.
No, okay, this is done on 27/9/2025.
Page 68.
That is the,
67.
reply to his email, Lordship, asking for it.
That is on 9th of October, 9/10.
Communicated, please check your email through which you must have registered in NPSC portal. So this was.
On 9th of October. We say no. We have made a statement, my lord.
Huh?
We have made a statement in the repetition, paragraph 7, page 11. We have not received any email, and I personally put the question to them. Now, what happened 9th?
Okay, you have sent by email.
That goes by the portal itself, Lordship. Once it is rejected,
You must be having a copy.
Lordship, I do not have at this point of time. I can take instruction on that point only.
Okay, taking stuff.
Now, I take 1 point further, my lord. Because if I'm not able to satisfy my lord that I have some credential, I'm not even entitled to any order whatsoever. Now, this certificate at 2
No,
pages,
but Mr. Bonik,
My lord.
unless this board knows,
my lord,
you say that they have not been intimated.
correct.
A document is there at Annexure E page 68,
My lord.
wherein they say that you have been duly informed in your email which is there.
True.
Whether that email you have received or not, as per you, you have not received.
My lord.
Is it? Now the question is, when they say so that they have sent it, should I
They
not
have
give them an
records.
opportunity
Yes,
to
yes.
find it out and place it before the court? on
But
the
one
next
thing
day?
I would be failing in my submission if I don't point out to the court, the particular certificate they require is no longer the law. The certificate which we have, we did,
No, how do you know about the certificate? You don't know what is the ground of your rejection.
no, not mine, not mine.
I'm not concerned with
No, I'm not
others.
even concerned with them. They are putting forward a requirement that the matter is,
Mr. Bonik, the fact remains
Very
that you don't know what is it's your technical
my lord, have been-
disqualification.
if lordship would have it on Wednesday. But,
Wednesday produce that email.
but if
Lordship.
in the meantime, the
No,
42 is
no.
allowed, I'm gone or dismissed. Allowed or dismissed. I'll go.
Lordship, I'll
That
place
protection be there.
another repetition, the email which was sent to them. I have a copy. I can just place it. Lordship peruses that. It will clarify as.
That's not to us.
It goes from the system, Lordship.
That's not to us.
It goes from the system. Maybe
No,
the
no, system
Correct.
also, if it is goes from the system, you must be having it in your records.
obviously, Lordship. We'll get this.
This email is,
This is another
you don't, you see, prior to sending an email, there must have been a decision-making process.
Yes, absolutely.
And the decision-making process did not happen in the e-portal.
Lordship, there's a minute.
There has to be a minute.
Yes, Lordship, that is.
So that minute you produce it.
Lordship.
With all respect,
You have been disqualified for participation in the e-auction system. Reason for rejected as OS certificate and seller of the seller 51 and indicated was not submitted.
Lordship, she's the sender.
This is for the other matter, na?
Different matter, Lordship. It is listed different, best no interim order with that. But the sender will clarify it goes from the system itself.
So what type of email you produce the next day, we issue notice, a short notice on 22nd or 24th?
24th.
Issue a short notice on 24th and fix the other matter. Where's the other council?
42, she's there.
40 days here.
43, who is there? We have it on the next date. Madam, that order passed by the learned ordinate bench, that was not proper.
Lordship, may I address you then on that, or will you hear me on Wednesday?
That cannot happen. Lord. You are allowing the writ petition at the motion stage. With due respect to the learned coordinate bench, you couldn't have, you have taken the role of what do you call the tendering authority. They may say the pre-existing document we will take or won't take. And if they don't take or they should take or not, that is the subject matter of judicial review. That is what I understand, unless the law had changed on the day on which the interim order was passed.
And a step further, whatever you take, whether it is legally acceptable as on date, that would weigh consideration, my lord.
Anyway,
Lordship,
we
are you
issue a
hearing
short
item
notice.
42?
No.
Are you hearing item 42, your lordship?
Yes.
Then may I address your lordship?
Yes.
My lord, any order there, since my lord has posted my matter on a different date, my lord, allowing or disallowing this matter would have a impact on mine, my lord.
Lordship, keeping on.
Lordship have all the matters on Wednesday, my lord. I'm free.
We'll have it on Thursday.
Thursday.
Thursday we finish it on. Because that order is incorrigible.
Yes, submit this. Extra.
Yes, submit.
Lordship, you're keeping it on Wednesday?
Your interim order is there, na?
Yes, your lordship.
What is the interim order pass? It is provided the auctioneer as involved will be subject to the
The others
outcome of the
participate, your
restitution.
lordship,
We participate.
and we participated.
Huh? Okay. Subject to the outcome of the writ petition means we dismiss the writ petition matter over.
So
There is
here I
less
take
of
it,
embarrassment from
without, since I am out of the bidding process, I do not know what they have bid, but my client says under instruction,
the-
100
Fantastic case, Mr. Boni.
crores.
And take a seat. We dismiss the other two writ petitions matter over. Okay, Agi,
Lordship, you're hearing item 42? Oh, we have
Yes.
done.
Agi.
Lordship,
So-
page 81 is our
You
impugned
had
rejection.
that particular document.
Historical document, your lordship. On the date of advertisement, 7/8/25, we had the certificate. Inadvertently, we uploaded the wrong expired certificate. So that is the.
Now, can the court direct when no decision has been taken by the respondent authorities as to accept or not to accept?
It has been taken.
Yes, your lordship. At the moment, right now,
Where is the judgment? Show me one.
lordship, yes. MDC, E2 High Court, Supreme Court, whatever like.
Where the Supreme Court have stated that the historical document.
Lordship, the two High Court decisions.
The High Court, I'm not bothered. Supreme Court said that a historical document at the motion stage can be allowed to be taken on record. Without hearing the other side.
Lordship,
Without giving them the opportunity.
Lordship, there is-
No, other side was.
No, other side was present, your lordship. AITC was present.
Well, not allowed them. You are on a
No,
motion
Lordship-
day. How do you pass a final order?
It's not a final order, lordship.
It was
It's-
a final order.
Lordship, no, no.
Allowing that to be used out there. Show
Lordship,
me a
give-
judgment.
Give me a moment. Let me explain. What was my argument? My argument was that the document that we should have uploaded is a document which was in our possession prior to the auction and advertisement process. So it is a historical document. It's not created post the advertisement
Where
ensued.
is the term in the contract that document, a historical document can be taken?
What two
Then
catena judgments?
everybody
Catena
can,
of
in every case, if you don't submit any document. Yes, if a historical document of A is being taken by the respondent authorities, but for B, the historical document is not being accepted, this court can interfere and say that you have to abide by this Article 14. But if you don't include the historical document, any document, unless the tendering authority says that, okay, we are going to accept the historical document, then the court would say, okay, we don't have anything to say.
Lordship, what was my
Here
argument?
The authority says that you did not submit this particular document, and as such, we are not accepting it.
Lordship, may I explain this auction process? It is not like the other tender processes where there is a technical bid and there's a pride bid. This is in a sense invitation to auction. So it is an auction where, what is an auction? The success of an auction is more players. That's how the state gets better price. So therefore, to technically qualify, they require a couple of documents.
Is it the role of the court that to enhance the compensation?
Lordship, in public interest, yes.
No.
That's what
That is not the role of the court to enhance the competition. It is the role of the tendering authority to enhance the competition.
Lordship, we came to your Lordship's court to say that our rejection is arbitrary.
A tender document, any clause by which a historical document can be.
Lordship, there are judgments of High Court,
High Court, no.
division benches.
Division bench, no. Division bench is for the division bench, for the
Lordship,
single bench.
No, I will rely on that judgment just to
Show
adopt it
me
as an
one
argument.
judgment, show me one judgment of the Supreme Court whereby such thing is allowed. This type of things cannot happen.
Lordship, finally, our bid is accepted. So we are the highest bidder.
So it has to be rejected. It is subject to the outcome, isn't it?
No, Lordship,
With respect, we not, I would object.
The moment we dismiss your repetition, your matter is over.
They cannot know it.
no, they can know
It is
it.
the highest bidder. I'm here filing a writ petition for that.
It goes by itself by the website.
It is an automated generated thing. I get it. That's a system. I can't fight it. The system is that moment the highest bidder, the auction closes, what is called the page 24, your Lordship. It's called the,
Where is this industrial assets transaction matter? 5860, that is also listed.
a system generated automated sale intimation letter.
Okay,
They only needed this.
so
Lordship-
you may be getting a better judge there.
Listed by,
Huh?
listed by itself. The two matters are listed before the same bench lots.
Not here.
Not here, the other two matters, industrial and the Balaji.
No, edifice is here.
Yes, your Lordship. Item 42.
Edifice is here, so
Yes, sir.
edifice, what is the order passed?
That is the order, Lordship, just read that, the intended for it.
Here
Lordship,
it says the petitioner counsel submits that a valid OSSA was issued to the petitioner on demand and before the date of issuance of the auction. And the same being a historical, the petitioner's bid ought not to have been rejected on the state ground and the petitioner was mandated even.
Rashmi.
And I have heard the party, the materials brought on admittedly the petitioner which they had not uploaded the valid OSSA and according the rejection of the bid by the so-and-so was proper. Having noticed the state position, this court also notices that the year on the last date of submission had a valid so-and-so. And it was on
And this
account
year it
and
will like
inadvertence that the state certificate was not uploaded. This court considering the fact the petitioner had
Jaldi jaba
valid
kare.
so-and-so as a year direct the response to allow the participate. The petitioner shall also be allowed to carry out the inspection of the site. Shall proceed to the site and carry out the inspection on completion of the auction. The result thereof shall not be declared without the further leave of the court. H3 so-and-so further orders as could be ruled for.
2, 5, 9,
This shall
12.
be based on instructions based on record by so-and-so. The repetition has been allowed.
So in fact, we place a judgment, Lordship, with the, which is, the certificate which is historical document not submitted on the date of technical evaluation will not be considered because that is not a matter of right to non-language mistake.
Absolutely.
That is
But what do I do? This repetition has been allowed.
Place the order, we place
Although
our.
it's a very sorry state of affair, a repetition being allowed without allowing the other side to have a, or even does not making it subject to the outcome of the repetition.
No, the result is not to be taken out.
No, results are not, but otherwise nothing remains. Shall be allowed to take part in the auction held on so and so. On completion of other, the results shall not be declared without the further leave of the court.
So it's subject to outcome.
We do one thing. We pass an interim order in your case. Not to declare the results. Sign it. Sign it. So So then you get that order.
So we're bidding 100%, but
Huh?
we say, we do not know, but still we are bidding.
We pass an interim order in his case, giving a here the cyanide not to declare it. In the disposal of the reputation.
He's also not technically qualified otherwise.
So what? Same thing, the same parameters should also be followed. If this is the same document on which you have not taken in consideration, that entire auction has to go.
Also not exactly similar because of the factual.
No, you have to, we therefore stay the entire process, taking into account that on one hand, by an order passed by the learned court net bench, she has got an advantage. An advantage, and if that is the reason why, if he had all the documents out there and you have not intimated, stay the entire process till the disposal of the reputation.
The technical beat of the item number 46.
No, I think you have a good case. We should issue notice, making it returnable on 8th of December 2025. 8th of December. 12th of December.
I'll just play through the.
No. You see, what has happened is, if his technique, you have not intimated him the rejection of the technical bid, which he says on oath, I have to state. Thereby, he could not have the opportunity to seek a redressal. And on the other hand, there are other people whom you have duly intimated for which they could come before this court. And there is a violation to Article 14, isn't it? Issue notice making it returnable on 12th of December 2025. Mr. Architect Chaudhary, you accept notice for response number 1. And number 2, number 2 is by State of Assam is you. M. Setia for response number 2. You have for response number 3.
Item number 2.
No, in this Mr. Bonik's match.
Number 3.
D Deca for response number 3, 4, 5. You have for 6. For whom are we?
It's not a big deal.
6 notices to be issued, na? Huh? And who is appearing for MSTC?
Union of India would be taking.
Are you going to take it?
MSCC has different councils.
Okay. So Mr. Architect Chaudhary accepts notice on behalf of respondent number 1 and 6. And you are appearing for, who is appearing for AIDC?
Item number 40.
No.
I'm here.
46.
So what is the difference between 3 and 7, Mr. Boni?
So far as 3 is concerned, this is the AIDC, and 7 we had also communicated in the Panchgram office.
How can you have anything and that too here? It is the same.
No, it's okay,
Same
but
state.
since we communicated with
1 and 7. And madam, you accept notice on behalf of respondent number 8, edifice.
Instructions we don't have whether you can appeal.
1 to 7, 8, 10, right? Huh? D data for respondent number 3, 4, 5, and 7. 6 of 1 and 6 him. 2 for him, and 7 here. As regards the respond number 8, steps be taken by way of registered as well as by way of speed post.
Lordship, it allows, if 2 minutes allow, I take a telephonic.
No, don't take. Respondent here by speed post. And so in addition to that, by Monday, by Wednesday. In addition to that, the petitioner is also directed to take steps upon the respondent number 8 by way of dusty.
sometime, could it be little bit late because the port would be closed? Just to do it to.
I'm asking you to
Yes, please.
take dusty service on or before the next day.
Next.
By dusty upon the respondent number 8. But to Amalan. The respondent number 6 had issued
You come here, your method.
and what is this, Mr. Monique?
My lord.
What is this? Respondent number 6, what have we issued? I've issued an auction notice. Of demolition, disposal and clearing of all buildings and other civil structures in plant and machinery area, bracket including intake area, bracket close, along with disposal of fixed assets inside the building of Kachar Paper Mill, bracket CPM, as per the material list. In as is, where is basis. The said auction proceedings where was divided into was in two parts. One is the technical bid and the other is the financial bid.
No, auction.
To auction. It is only when a bidder is technically qualified, the bidder can submit the bid for the auction. The petitioner, along with various other bidders, submitted their technical bid. It is the specific case of the petitioner as set out in the writ petition that the petitioner was never informed that its technical bid was rejected. Rather, on various inquiries being made, an email was sent on 9/10/2025, stating inter alia that the results have been already communicated, and the petitioner was asked to check in its email, which have been registered in the MSTC portal. Immediately thereupon, On 13th, the auction took place. And under such circumstances, the petitioner could not participate. The case of the petitioner as submitted by Mr. S. Bonik is, had the petitioner been intimated the reasons why the petitioner was not permitted to participate in the auction process, the petitioner could have availed his right to challenge the same if it was permissible under law. The right to redressal of the petitioner was taken away. Which is a constitutional right as submitted by Mr. S. Bonik. On the other hand, Mr. S. Bonik further submits that various other bidders were duly intimated about the reasons why their technical bid could not be, why they were disqualified. And these bidders duly approached this court and filed a writ petition. And this court and the learned coordinate bench of this court had passed appropriate directions allowing them to participate. The Mr. S. Bonik further submitted that on the basis of such orders being passed in WPC number 5859/2025 and 5868/2025.
Interim order is only the first one.
Others, what has happened?
Others, they said they did not have the document, so it was not allowed. The interim protection was not given.
On the basis of 5859/2025. The petitioner therein could very well participate. The petitioner therein, who is the respondent number 8 herein, would very well participate on the basis of an interim order. And it has been brought to the, Mr. S. Bonik further submitted that though the petitioner had all the required qualifications, but for reasons best known, the respondent authorities did not intimate the petitioner. Mr. S. Bonik further referring to page Annexure K to the writ petition stated that the very certificate which was even permitted by the learned coordinate bench by the order dated 9/10/2025 in WPC number 5859/2025. The petitioner also had that said certificate.
The correct one, in fact. Annexure J says their document is not even acceptable.
No, has that certificate. The learned counsel further submitted that if the petitioner would have been permitted to participate, the petitioner could have quoted
100 crores.
Could have, or have you?
We will still without the on-site thing. If permitted, because it's in the seal cover, they know, we do not know. Whatever there is, we'll quote 100 crores.
Taking into account the stand taken in the writ petition, this court inquired with Mr. B. Decker, the learned counsel appearing on behalf of the respondent authorities, who were the tendering authorities, as to whether the petitioner was duly intimated. The reasons. The learned counsel submitted that he has no instruction as to what were the reasons for which the petitioners were not held to be technically qualified. You have the minutes with you.
I do not have Lordship had asked me to place on record the email by which it was sent. I submitted it was sent by.
You have the minutes.
Yes, Lordship, I have. We have also submitted in 585.
What is your minutes? What is the reason?
Reason is they did not. Well, among the red color is making it above the red color. Lordship. Yeah, also please one part. Lordship.
Same reason.
Lordship, not exactly same, Lordship.
Exactly same.
Lordship, it says second part of the requirement, Lordship.
Second part is also there here also, edifice also.
Lordship, the,
Can you see, the edifice also says so.
Lordship, it says, which self-attested copy of seller's safety terms and conditions stated in STC.
No, no, Mr. Counsel, safety thing is here also.
Lordship, the document which they have submitted before this code in this repetition is, Lordship, not up to date, Lordship. It was up to date in 25/8/2025, which is not part of the record in the repetition, Lordship. Which he have submitted as an annexer is an outdated bid document, Lordship. And also he has not submitted the document, bid document that he has annexed to rely on the certificate which was sought for. It is not the correct one, Lordship. I'll submit it. It was corrected in 25/8/2025.
If this is the case that OHA's certificate was sought for, if they say, my stand is that this is not the document which is required under the law. I'm not challenging that, but I said I have the correct document, or albeit I did not submit, and I informed them earlier also. My Lordship has my email at page 67. I informed them. Prior in hand. That was 27th of September. I informed them.
Submits that the reasons for the rejection of the technical bid of the petitioner.
We want a self-attested copy of the safety terms. It is at page 53.
Where that the OHSAS certificate was not submitted. And the self-attested copies of the seller's safety terms and conditions as stated in STC document not submitted.
That's page 53.
To stop. Just go further. He further submitted. That in respect to edifice engineering, which is the respond number 8. The said ISO certification, which was submitted had expired before the auction advertisement date, and hence edifice engineering was also disqualified. But on account of the order passed by this court, the respondent number 8, that is edifice engineering, had been permitted to stop. This court, having heard the learned counsels appearing on behalf of the parties, And having perused the order passed by the learned coordinate bench dated 9/10/2025 in WPC number 5859 of 2025. Is of the opinion that as the petitioner was not, it is of the opinion that as to whether the petitioner had the technical qualifications required as per the terms and conditions. And he is of the opinion that prima facie, nothing has been placed on record to show that the petitioner was duly intimated about the disqualification. Considering the above, this court is of the opinion that the respondent authorities have applied two yardsticks insofar as the case of the petitioner vis-a-vis the respondent number 8. And because of the fact that the respondent number 8 was duly informed, the said respondent number 8 could approach this court, and on the basis of such approach, the respondent number 8 could participate. Had the petitioner been intimated, similar considerations may have befallen. Considering the above, this court is of the opinion that the further is of the opinion that till the next date, the tender process corresponding to auction number MPS GHY Assam Industrial Development Corporation Limited /5 Guwahati /25-26/25321 in context with detailed auction catalog dated 8/8/2025 shall remain stiff.
Grateful, Bill. Obliged.
Yeah, item 42. List this matter again on 12/12/2025. Interim order passed earlier shall continue till then.
Like your lordship.
Highest bidder, and his name was recommended by the my lord, standing committee of Panchayat, my lord, Gaon Panchayat. But
Which part that?
my lord, Kazaikata page, my lord, kindly see page 18,
Kazaikata part 2.
Kazaikata part 2. The government value was 25,000.
You are the only bidder,
No, there are other 11 bidders, my lord.
but all are unfit.
Yes, ma'am.
You are the technically competent.
Yes, ma'am.
But you have a
Accordingly,
criminal case.
his name was recommended. His name was recommended by the standing committee.
But you
Yes.
have a criminal case.
Criminal case is there, but BDO has no jurisdiction, my lord. BDO has no jurisdiction. Executive officer has no jurisdiction. If there is any dispute regarding anything, regarding Panchayat, under the Panchayat, the chief executive officer, Jila Parishad is the my lord authority, my lord. Accordingly, I filed my lord application before the my lord chief executive officer, Jila Parishad, page 49. Against the order passed by the my lord BDO, my lord. That is also pending.
Then
Presently, my lord, the petitioner was allowed to, my lord, run the ghat, my lord, on his bid value on temporary basis, my lord. And he is running, my lord, but he, my lord, hired the, my lord, boat, my lord, as well as we made agreement with the, my lord, boatman, boat owner, my lord. And my representation is pending, my lord. In the meantime, my lord, kindly see impugned order, that is, my lord, page 43, my lord.
So you say that this particular communication of 26/9 is
Yes.
required to be set aside, taking into account that the video has no business.
Yes, my lord, that is the law, my lord.
Yes. But
Section
as per the
106.
tender condition, you cannot have a criminal case against.
My lord, criminal case is pending regarding, my lord, some dispute between two groups, my lord. But the condition in the tender, my lord,
No, but tell me, as per the terms of the tender,
yes.
as well as the Assam Panchayat Act and the rules, can a person having a criminal case with him, against him, be granted a settlement?
It says, my lord, violence activity, persecution. So person should not be involved in violence activity, persecution, etc., my lord. It does not say criminal case, my lord. Nearly
Provision.
pending.
Where is the
criminal-
provision?
Yes, my lord, in the tender.
Wording
itself,
is at page 21,
Page 21, my lord,
article level. Was 90.
close 19, my lord,
Yes.
close 19.
Close?
Close 19, my lord, 19. যিকোনো ধৰণৰ হিংসাত্মক কাৰ্যকলাপ, অত্যাচাৰ, শোষণ, নিপীড়ন আদি জড়িত থকা নিবেদনকাৰীক হাত, ঘাট, মিনমহল, পাউণ্ড আদিৰ বন্দোবস্ত দিয়া নহব।
And I have checked, my lord, in the website, my lord, the official judicial website, that after the filing of the charge sheet, PRC case 488 2022 was registered
Yes,
and
that-
trial is going on.
That is there, my lord.
488 PRC case 488 2022 that was registered and now is on trial stage, my lord, evidence stage.
And this is case registered under?
Registered under my
Section
lord,
one.
under section 143, 341, 323 CIPC.
IPC.
Yes.
322
registered in
what?
20
Huh?
It registered in 22, my lord. Itself. Since 2022, it is going on.
But does the BDO come executive officer has the jurisdiction?
No, my lord, section 1064, my lord.
My
Section
lord,
1064.
I have to take a short date, maybe fix mine. I'll take an instruction on that, man. How it was there with mine. Maybe next week,
Section 1064, in case of any dispute in settlement, the concerned Gao Panchayat and Anchalik Panchayat may refer such cases to the Jila Parishad.
106?
4, my lord.
All settlements made under subsection 3
No.
shall be subject to the confirmation of Jila Parishad? What do you read?
106 subsection 4, my lord.
That is what?
In case of any dispute.
Huh?
1064. Kindly take my book. Yes, ma'am.
This is further amended.
Yes, my lord.
This is not a dispute in settlement. This is not a case of dispute in settlement. The question is whether there can be a settlement at all. Taking into account
Yes.
that this person concerned has a criminal case against him.
Yes.
Now let us see your registration of the FIR, the criminal case.
Yes, that is, my lord. FIR is page 44. But charge sheet is filed, my lord, under section, my lord, 143, 341, 323 IPC.
325 and 379 theft.
That is, my lord, not in the charge sheet, my lord.
Where is the charge sheet?
Charge sheet I have not, I have stated, my lord, in my.
That is the most important thing. You should have enclosed.
Page 11, I have,
379 is not there.
yeah, I have stated, my lord, page 11, my lord, page 11 in my.
Why have you not enclosed the charge sheet?
And charge sheet is there, but it is not fully eligible.
You therefore want to say that clause 19 would have no relation. So the most pertinent thing is that 143, 341, 323. CRPC consult?
IPC. IPC continue.
CRPC conjunction. CRPC. CRPC. नहीं को नहीं पता इन लोगों को But Mr. Dotto, whether this person has the authority?
That for that, my lord, how it was dealt with, my lord. Lordship may fix the matter on the next week. I'll take proper instruction. How this was dealt with.
So notice making it returnable on 27th of October 2025. Mr. S. Dotto accepts notice on behalf of the respondent numbers 1, 2,
My lord,
3,
1, 2, 3, and 4.
and 4. So for the present, this court is not inclined to issue notice upon the respondent number 5. The petitioner hearing is agreed by the action on the part of the respondent number 2, or respondent number 3 in cancelling the tender pertaining to Kazai Kota Part Roman 2 Parghat on the ground that the BDO come executive officer of on the ground that the respondent number 3 has no authority or jurisdiction to cancel the tender in view of section 106 of the Assam Panchayat Act 1994 as amended up to date. Further to that, it is also the case of the petitioner that the registration of the PRC case number 488/2022 cannot bar the settlement to be made in favor of the petitioner in terms with clause 19 of the terms and conditions of the tender. The learned counsel appearing on behalf of the petitioner therefore submits that the impugned order dated 26/9/2025 be stayed pending the notice, pending the next date. Taking into Mr. S. Dotto appearing on behalf of the respondents numbers appearing on behalf of the respondent authorities submits that he would obtain instructions taking into account that the petitioner has been able to make out a prima facie case of stay of the impugned order dated 26/9/2025 on the ground that there appears to be no power on the ground that the respondent number 3 had no authority or power to cancel the tender. This court is of the opinion that this is a fit case for stay of the impugned order dated 26/9/2025 till the next date. Taking into account that this court had passed an order of stay and there is no settlement, the respondents, the Anchalik Panchayat would be at liberty to run the Sheikh Parghat in terms with section 105 till the next. Huh?
May I point it out one thing, madam?
Yes.
Lordship may kindly have page number 19 once again, because this is the NIT, my lord. NIT it was written as, my lord, Gaon Panchayat, but it was issued by Anchalik Panchayat only. The executive officer, he has issued, my lord, page 23.
Secretary sign also there, my lord. Secretary of Government in the left side.
Please have it. Anyways, you are running it.
Yes, yes.
Obligation.
48. Made, please, your lordship. Lord, the petitioner is an dealer of LPG. Now, certain fine has been imposed.
Oh, that one, same order. I passed similar orders, something like that?
No,
This is different.
Yes.
This is after that.
this is in respect of, they are not meeting the required timeline for delivery. And that is
Oh,
the reason.
Okay.
Look, there is a concept called targeted delivery time. Now, if your lordships would kindly come to, before I take your lordships to the show cause notice, if your lordships would kindly come to page 77, my lord. The idea is to ensure that the consumers get the cylinders in time. Please see delivery control 4.1. Please come to 3, my lord. TDT means targeted delivery time. TDT performance envisages rating of distributors based on quarterly performance of the financial year. 1st April to June 30 is the quarter one. So this is how, my lord, there are 4 quarters. Then, my lord, please come to 4.2. Action to be taken for not meeting TDT norms. Then if your lordships would kindly come to page 78. Now, I'll have your lordship's kind attention to Roman 5. Action against distributor performing at below average rating. In all established cases where a distributor performs at below average rating during any quarter, a fine equivalent to 10% of AMDC, that is the commission which is payable to the distributor as defined in chapter 6 shall be imposed. So in case the performance is below average during any quarter, then 10% of the AMDC will be deducted. Then, my lord, in our case, we are concerned with B. In all established cases wherein a distributor performs at below average, a rating during any quarter subsequent to 4A, that is 1 above, we are not concerned, or 5A above, within previous 4 quarters, a fine equivalent to 20% of AMDC as defined in chapter 6 shall be imposed on the every instance of below average performance rating. That means, my lord, if in any quarter the performance is rated as below average, then 10% will be deducted. And if in any 4 previous quarter the performance is below average, then 20% will be deducted. These are the enabling provisions. Now, my lord, will kindly come to the show cause notice, which is at page number 48. Well, I am assailing the decision-making process. For a moment, I am not questioning their power to impose fine in the form of so-and-so. Kindly similar, 1725. I'll have a lordship's kind attention to para 2. As per marketing discipline guideline 22, the distributor should ensure that distributorship operation is not rated with 1 star, that is poor rating, 2 star is below average rating in a quarter, failing which action shall be taken as per relevant clauses of the referred guidelines. Your TDT performance as available on transparency portal during the actually, my lord, I think it should be a typographical error. It has to be 1st quarter, that is from April 25 to June 25 have been found to be below average. You may view the report from the portal
for your reference. So the allegation is in the first quarter, that is from 1st of April to 30th of June, my performance has been rated as below average. So I was asked to show cause. Lord, I submitted my reply. Then I have cited the reasons. Now please come to the impugned order at page 54. This refers to a letter dated so-and-so wherein you were requested to provide an explanation as to why disciplinary action should not be initiated against you under so-and-so. We acknowledge receipt of your response. However, after due examination, justification provided have not been found satisfactory for the following reasons. You have cited insufficient load supply from the plant as the reason for below average performance. Lord, in support of this, we have annexed material at page 30 to 36 of the writ petition. That means, my lord, load supply was not adequate. It was not in time. It has also been mentioned that interference by drivers union at the plant caused delays in your supplies, resulting in below average. They say others have not complained, therefore we are not entertaining your complaint on this count. Others may not, but I have. Similarly, my lord,
Mr.
okay, my lord, I am not on this.
Mr. Chaudhary, tell me one thing.
Yes.
A reading of clause 4 to 4
To B.
Roman 4A,
Huh.
4.2 Roman 4A
Yes.
shows about poor it,
Huh.
10-20%.
Huh.
4 to Roman 5A is 10%.
Huh.
Go to Roman 5A is my lord.
10%.
For any quarter, 10%, yes.
Here we are concerned with one and you are categorically saying below average.
Huh.
So 4 to Roman 4A would not come in.
Yes.
It's not poor. Unless you have a reference that in other earlier 4 quarters there was a
Yes.
problem.
Ah.
How do you have 4 to Roman 5B?
Your lordship is right, my lord. But I have got instructions, my lord. May I read the instruction before?
But the agents, shouldn't it be a part of your order?
Huh.
Instruction is different thing, but
Yes.
shouldn't it be a part of your order?
That is not
Yes,
written.
10% you can. If it is a below average, is a different thing. You can. But the question is, how can you have for 20%? Unless it is a part of the order showing
Yes.
that for the earlier periods, it was
It is not that reflecting in the order. That's
But
right,
then-
my lord. But the portal is, my lord, transparent and they know, my lord, their ratings every
so
day.
therefore you have to mention, don't you think? It is
That
required
that
to
has
be
not been
mentioned.
mentioned. Here also is right in that, my lord. That has not been mentioned. But
We
the
state this
instructions have-
particular document,
Huh.
the imposition of 10%, not 20%. 10% we stay. Because 10% because even if assuming, which will be otherwise subject to the outcome, if it is found later on that there could not have been a below average, we'll look into it later on. There is a particular
Prima facie.
explanation given by him. Whether that explanation is justifiable by this court. But prima facie it appears you on the basis of this order, on the basis of the show cause notice. Show cause notice, you do not mention anything that you are going to take steps in terms with order 4 to Roman 5B.
B.
And the order also does not say on what basis you arrive at 4 to Roman 5B.
That your lordship is right, but the
हमारा
my
reply
my
तारीख
submission will be.
45 दिन के तक
My lord, this is not something, my lord, which is kept on a record with the IOC only. This is always available, my lord. That's not.
Understood, but shouldn't it be a part because it categorically mentions that you have not done for this period to this period. You have not mentioned a single thing that
Priority
4
also-
quarters.
Your lordship is right.
Therefore, we stay. This will be subject to outcome whether now you deduct 10% or ask him to pay the stays of this letter is subject to payment of this 10%. Out of this 2,18,000, you will pay 1,09,000. Remaining remains And however, as to whether the imposition can be made or not, that will be subject to whatever you say.
In fact, my lord, whatever we pay today will be subject to the outcome of the
No,
case.
everything will
There's
be
one more
subject to
point.
outcome.
That absolutely, my lord, that was my argument only. One more point, my lord, please come to page 78. Because we are assailing the decision-making process.
Hmm.
Please come to my lord, Roman 9 towards the bottom of the page.
Hmm.
Upon receipt of reply to the show cause notice, concerned divisional LPG head, territory manager, regional manager will review the charges level in the show cause notice and the reply received and then pass a speaking order within 45 days from the date of receipt of the reply. Now this order has been passed beyond 45 days. my lord. Because if a manner is prescribed, it has to be done in that manner.
And then pass a speaking order.
my lord.
And
Then pass a speaking orders.
That is not the thing. I will look into.
Lodge will keep this question open, my lord.
That is okay.
Since it's a
We only, this is state subject to you depositing this 1,09,000.
Yes.
And as to whether that 1,09,000 would be recoverable by you is subject to outcome of.
And whether I'm further required to pay, everything will be
that
subject to
will
the.
This is a matter of money, my lord, that can be recovered if, my lord, from the IOC also.
Whatever may be, or if it is apparently appears, I can't help it with that.
That's why we said, my lord, at the very beginning, I'm assailing the decision-making process. I'm not questioning your power.
You notice making it returnable on, when can you file your affidavit? December?
2 or 3 weeks.
So issue notice making it returnable on 10th of December, 2025.
My lord, under this scheme, we are not supposed to pay. The commission is payable to us from that day deduct. That is written in page 55, my lord.
Although you are hereby advised to remit
Page
the
50,
penalty.
page 55, my lord.
The page 55, it says you are therefore advised to remit the penalty.
Into your product.
Anyway, my lord.
They will remit, I will say, they will remit to 50%.
Yes.
Mr. M. Sharma accepts notice on behalf of the respondent numbers 1 to 5. Some extra copies of the writ petition be served upon him by day. You can serve it today.
Yes.
The petitioner herein is agreed by the order dated 19/9/2025, whereby the respondent authorities have imposed an amount of rupees 2,18,614 as penalty on account of in terms with clause 4.2 bracket Roman 5 bracket small b of the
Page 56, madam.
Marketing discipline guideline.
Marketing Discipline Guidelines 2022. Mr. Kane Chaudhary, the learned senior counsel appearing on behalf of the petitioner, has drawn the attention of this court to clause 4.1 of the said guidelines. Hereinafter, for short, the guidelines. Refer to clause 4.1 of the said guidelines, which deals with targeted delivery time norms. Specifically referring to clause 4.2, the learned senior counsel submits that this particular clause shows shows as to how action can be taken if the targeted delivery time norms are not met. Specifically referring to clause subclause 4 of subclause 4, Roman 4 of clause 4 of the guidelines, the learned senior counsel submitted that the said clause, subclause shall is only applicable when the rating is poor. On the other hand, if the rating is below average, subclause 5 of Roman 5 of clause 4 would be applicable. Drawing the attention of this court to the show cause notice dated 1/7/2025, the learned senior counsel submitted that the allegations made therein is pertaining to below average during ratings, below average rating during the third quarter, that is April 2025 to June 2025. In pursuance thereto, the petitioner had submitted the show cause reply, giving details that it was not the fault on the part of the petitioner which resulted in not meeting the targeted norms. However, contrary to subclause Roman 9 of clause 4.2, the respondent number, who is that the respondent? That person. Divisional sales head.
Divisional LPG head.
Whoever. Respondent number.
Respondent number 2.
Contrary to subclause Roman 9 of clause 4.2, beyond the period of 45 days, the impugn order was passed whereby the petitioner was imposed penalty at 20%, which is actually earmarked in terms with clause 4 in earmarked when either when the rating is poor or it is below average rating subsequent to an adjudication made under subsection subclause Roman 4A or 5A within the previous 4 quarters. The learned senior counsel submitted that without any rhyme or reason, the respondent number 2 have imposed 20%, which could not have been done as per the guidelines. The learned counsel, senior counsel further submitted that in the instant case, the question of imposition did not arise at all, taking into account that the petitioner could not meet the target on account of circumstances beyond the control as stated in his reply to the show cause. Par contra, Mr. M.K. Chaudhary, the learned counsel, senior counsel appearing on behalf of the respondent numbers 1 to 5 submitted that the grounds and reasons which have been mentioned in the show cause reply have been looked into by the respondent number 2 and finding the same not to be tenable, the imposition have been made as per the impugn order. He therefore submitted that the question of interference with the impugn order at this interim stage does not call for taking into account that the issue involved is question of payment of money. This court have duly heard the learned counsels appearing on behalf of the parties on the issue of interim prayer. You have made an interim prayer?
Yeah.
Okay, interim prayer. Interim prayer. From a perusal of the show cause notice, as well as the order, impugn order, there is nothing on record to show that that the petitioner had a poor rating for applicability of clause 4.2 Roman 4A, or there is already an adjudication made in terms with clause 4.2 Roman 5A for applying clause 4.2 Roman 5B. And as such, on the face of it, the imposition of penalty at the rate of 20% is not called for. It is the further opinion of this court that as to whether there should have been an imposition of penalty or not can only be dealt with by this court at the final hearing after the stand of the respondents are brought on record. So, be that as it may, as apparently on the face of the record, it is apparent, and as on the face of the record, it is apparent that the impugned order is contrary to clause 4.2 Roman 5A, comma. This court is of the opinion that certain interim directions are required to be passed. Accordingly, this court therefore stays the impugned order dated 19/9/2025, subject to the petitioner remitting 50% of the amount of penalty into the petitioner's product account of the Indian Oil Corporation within 15 days from today. Number two, the question as to whether the petitioner would be entitled to the amount of 50% or the petitioner would have to pay the entire amount shall be decided at the final hearing of the instant petition.
Deep reply.
For admission item 5, part third.
May I please?
Oh, yes. What has happened?
Well, the proposal has already been mooted, madam, for payment of rent. May I fix it?
And are you going to take it?
Well, the SP Kasar on the last occasion just filed the affidavit that that building is required for him at least.
My lord, we are praying for vacating our building, my lord. And in my petition also, I have a prayer, my lord, by paying our area rent, my lord.
They have taken from when?
From 2019, my lord.
And what about the earlier period? You have
Earlier
put money?
No payment has been made, my lord.
But for that point, probably, my lord, it is a deputy commissioner now, my lord, who has disputed, my lord, the possession of the building. That will have to be decided by you.
Huh?
Because in the affidavit filed by the deputy commissioner, he has disputed that, my lord, he has taken over possession of that particular building.
But subsequently, SP Kachar have admitted the
Yes.
occupation of building, my lord. So, my lord,
That
from
point, my
1/9
lord, they are going
2000.
to pay. 1/4/23,
This is only the police.
only the police.
And what about the earlier
That
period?
part, my lord, so far as the deputy commissioner in the affidavit he has disputed, so Lordship will have to decide that.
Exactly.
And pass a final order. And regarding the, my lord,
Where is the affidavit of the deputy commissioner?
Affidavit, my lord, starts from page 63.
Page?
63. 63, my lord.
63.
64 starts para six.
There are 6 and 7 he has stated, my lord. And 8 also. Last page. And there are 22.
Para 22 also your lordship may peruse in this affidavit, my lord. One hand, he refused to hand over this building, my lord, and other hand, he page 22, your lordship. That's totally misleading, my lord, in fact. Page 68 also, your lordship may kindly.
No, but the deputy commissioner categorically say that it would not have the rental, it would not be responsible for the rental value with effect from 1/4/2023.
That part, my lord, the home department has now mooted the proposal.
It's okay. But the question is the deputy commissioner categorically mentions
Yes, my lord, that from now on I will not be responsible. So, yes, that statement, my lord, if you.
it seems that the deputy commissioner
The-
is trying to play hide and seek with the
Yes, my
court.
lord, exactly.
We
That's
should
true, my lord.
speak the
Difficulty-
appearance of the deputy commissioner.
My lord.
It seems that he is playing hide and seek, that he can
The
take.
main thing is this.
First of all, the deputy, this is a case where it is a very serious case.
My lord.
On one hand, you first say you don't know who is in possession. Then this court finds out through Mr. S.P. Sharma who is paying the electricity bill.
Exactly.
Then we come to know it is being paid by the government. When this court takes up the stand strongly and asks the SP to appear, now SP's, it has come up that from 1/4/2023 till date, they will be making the payment. One. This is for them. The deputy commissioner categorically says that he does not know anything. That he is going to not be responsible after 1/4/2023. The deputy commissioner is aware from when they are in possession.
May I reply? ma'am?
Yes.
Well, the entire tender process started in 2019. There was a necessity, so it was uploaded and accordingly, my lord, petitioner participated. Now, my lord, this affidavit was filed sometime in 2023. And on record, maybe the same deputy commissioner is not there, my lord. Whoever is there, he will go by the record. There is nothing on the record. to
24,
show
my
that-
lord, affidavit filed on 24.
Yes, in 2024. So whoever was there in the post of deputy commissioner. going by the
Presently, he is
record, has
posted, my
filed the
lord.
affidavit.
He is posted, my lord, Birul Kumar Jadhav, my lord. He is posted, my lord. He may be personally appear before your lordship. He clarify this, my lord. Since he has been fast, he has falsely stated before your lordship
On
to an
that I
affidavit,
agree,
my
your
lord.
lordship. But my lord, if your lordship grant me some time, my lord, because half of the part now. my lord,
Mr.
is very
Gogoi,
clear.
I tell you one thing, the deputy commissioner cannot play this hide and seek business.
That-
They have been writing letters after letters.
My lord.
They have not mentioned anything.
Even in the COVID time, my lord, they have used that building.
Kindly
my lord.
come to page, as intimated, a building at so and so was selected, observing necessary for accommodation of 9 numbers of FT. Subsequently, work order was issued to the owner of the building. Provide order number so and so to complete the renovation work of the building as per the provision. According, the owner of the white letter that had intimated the office that the building was ready to be occupied for the purpose of the fire. The owner is pursuing for payment of the outstanding rent. This is written by the additional deputy commissioner. Thereby admitting that the the building was made ready and handed over. At page 41 or 47,
47, my lord.
47.
Annex 10. On 15th November 2022.
Considering the present development, my lord, if lordship is allowed, I am not, my lord, against that, my lord, personally, so these honorable court so helps. I can have a short instruction, my lord, now, considering the present situation, my lord.
No,
Because
Mr.
the building is required
No,
approval.
there are two things.
My lord.
Mr. Gugoi, you have to take up the matter with these officials out there
My lord.
and ask them as to whether they are hard, they cannot come up and say hide and seek out there.
My lord.
They are, this is our state. When it is a state, it is the state who has come clean with the clean hands before this court. They are not private litigants who may say anything.
My lord.
Exactly.
These are based on records. The handing over the possession has been done, everything has been done, and now the deputy commissioner on categorically says that no, the hand over the possession, he did not make it ready and all this thing. How can there be a work order issued to anybody else after doing this
Well,
particular
I will
work?
have the specific instruction, lordship may record it in the court order. If nothing comes up, then lordship may take a call. Yeah, yeah. And sort that matter because it's from the deputy commissioner. only. I can have it.
And you may have to requisition the building.
Oh,
If
it's
he does
required
not
now, my lord.
want it,
Now,
if
my
he
lord.
does not want it, you
Lord.
cannot forcefully occupy.
No, once
My
the-
lord,
my lord-
exactly, my lord.
Now, my lord.
They
the-
cannot forcefully occupy my
Once
building.
the building, my lord. A formal agreement can be executed if at all the petitioner, my lord, agrees to that, fixing the rent and all. So that, my lord, he gets it regularly because he is offended because it has not been paid. Of course, my lord, anybody will be offended. My lord. But not in this manner. There will have to be some official.
The official has to be done, but the government is not doing anything.
My lord.
This is not how it is. Pursuant to the order passed by this court on 22/9/2025, it is seen that the Assam Police Headquarters have issued a instruction to Mr. B. Gogoi, the learned additional advocate general, stating that there is a financial sanction of rupees 40 lakhs 18,700 made against 25 months of rent with effect from 1/4/2023 to 30/4/2025, which have been uploaded in the government portal.
My lord, the proposal has been processed today. I've got the information from the, my lord, Home Department. It has been processed today.
Huh?
This proposal has been processed today. It has been moved.
And
Mr.
how they
P.
have to
Gogoi further
assess
submits
the
that
rent,
the
my lord, that.
said proposal have already been
Processed today, my lord, that's the
processed today
lordship by the Home Department.
by the Home Department. And the petitioner is likely to get the said amount on or before.
That time. My lordship, a fixed time.
Yeah. It has been already processed today. This court inquired with Mr. B. Gogoi, the learned additional advocate general, as to what is the deputy commissioner, district commissioner, Kachar, na?
Kasar, my lord.
Kachar, is doing in respect to the rental for the period from 19, na?
1
19/2019 till 31/3/2022, 23.
23.
Mr. B. Gogoi, the learned additional advocate general, drawing the reference to the affidavit filed by the respondent number 7, submitted that the district administration disputes the said amount. This court had duly perused the materials on record, including the communication dated
It's 47.
15th of November 2022, issued by the Additional Deputy District Commissioner Kachar to the Deputy Commissioner, Deputy Secretary to the Government of Assam Home and Political Department dated 15th of November 2022, as well as the communication dated
Page 50 also, Lordship, may, page 50. Within the government and the deputy commissioner. 50.
the communication dated 30/5/2023, issued by also by the Additional Deputy Commissioner to the Superintendent of Police, which categorically shows that the district administration is in occupation of the premises of the petitioner. It appears that the stand which have been taken by the district administration does not inspire the stand which has been taken by the respondent number 7 in the opinion of this court, and it does not inspire the confidence of this court. And it appears that the respondent number 7 is trying to not place the correct picture. The respondent number 7 is an responsible officer of the state of Assam. And it is expected that such officers should come up with place the materials such officer should place the correct facts before this court. First of all, at the instance of Mr. B. Gogoi, though this court was not satisfied at the manner in which the respondent number 7 is dealing with the matter, this court, however, at the instance of Mr. B. Gogoi, the learned Additional Advocate General, grants an opportunity to the respondent number 7 to place before this court as to when the possession was handed over to the respondent number 7 by the petitioner of the building, and further produce the records pertaining to the taking over of the building of the petitioner before this court on the next date. List this matter on 1st of December 2025. In the meantime, this court further expects that the Home and Political Department of the Government of Assam shall make all endeavors to release the amount of rupees 40 lakhs, 18,700 to the petitioner.
My lord, it may be treated as a part heart, my lord. Earlier,
It is
it
already
was
part
part heart.
It is already part.
My lord.
You are paying for respondent number 3.
Yes, my lord, I am in respondent number 3. Respondent number 2 also received notice today itself, my lord. Respondent number 2. Respondent number 2 is the main party to disclose all these things, my lords. But on behalf of respondent number 3, we have already filed.
But madam, tell me one thing. You have initiated what you call blacklisting proceedings against him
Yes, my lord.
without issuing any
I have prepared a brief, my lord, of the case. I have prepared some brief of the case, my lord. Small.
that affidavit I have not got. You have filed for-
Exactly, my lord. number 610 letter dated 24/5/2003. Everything is clear on that letter, my lord. Yeah, page number 6 to 10, my lord.
And this is pertaining to termination.
Termination and blacklisting also, my lord.
And now here,
Never.
what the petitioner's counsel on the last occasion say. So the officer said that taking into account that there is an arbitration clause in the agreement dated demand.
Yes, my lord.
The instance is limited to the action of the respondent blacklisting for an indefinite period, while the impugn order dated that too without issuance of any show cause notice.
So first notice was issued that in the blacklisting line, no, that is in case number.
Of your affidavit,
My affidavit, my lord. Actually, affidavit, I have annexed whatever the.
show cause notice for termination on account of violation.
Yes, my.
That is 10/6/2021,
2021, case number 184, my lord.
184.
Yes, ma'am.
But that is nothing to do with blacklisting.
No, blacklisting.
Where? You are therefore requested to show cause as to
Yes.
why the MOU not terminated on account of serious violation on your part. The desired reply may kindly be sent to
Yes,
the
got it.
feeling which nothing admits to answer is liberty to initiate appropriate action in the matter.
And
Wait.
blacklisting is in. Regarding blacklisting, my lord, that is in page number, in my brief of the, that is later that 27/1/2025, last one, my lord. There was the one proceeding in 9/1/25. After that, my lord, they have issued this notice, my lord.
Which one?
27/1/2024, 5 minutes.
27,
1/2025.
where is that document?
It is last. It's given.
It's annexed.
Page 73.
27/1/25.
Ah,
27.
this is the part of affidavit.
No, not the part of affidavit, not the, my part of that, my lord, short part of that.
Huh?
Short branch of the, that is the part of that, not my affidavit.
Why haven't you enclosed this? This is
My
the
lord,
most
what
likely
happened, my
document.
lord, whatever I have filed before the court as an affidavit, my lord, that is the document from respondent number 3. And respondent number 2 received the notice today itself only, my lord. So
Three.
today, my lord. So my lord, they have sent some document, my lord, whatever possible, that's now only, my lord. So I have a humble prayer before court, my lord, that on 22nd, immediately after reopening,
Just give me a copy, please. Let me have a copy.
This is a document of 27/1/2025.
yes, ma'am, in the last para, my lord, that is about blacklisting and all this.
7/1. This one is short. Give me. Give me a copy, please.
Now, this is a letter written by somebody to somebody.
Yes, my lord,
This has nothing to do with a letter show cause notice issued upon him.
yes, ma'am. Propose not
The
to.
question is whether you issued show cause notice upon the petitioner before blacklisting.
Yes, my lord, for that, my lord, kindly, my lord, take the matter on immediately after Diwali, reopening, my lord, because they have received the notice today, my lord, that's on the number 2. And tax service was on page, that's number 3, with the taxi service on page of this month, my lord, October. In short time of period, my lord, I have whatever I can do, my lord, I have filed this affidavit, my lord. So I'll already I have contact respondent number 2, my lord, itself, and they have also contacted me, my lord.
We have it on 28.
Yes.
28.
Wait.
To yeah, very good.
So that I'll place all these documents, my lord, from respondent number 2, my lord.
October 28.
You file your affidavit
Yes.
by 24th?
Yes,
The last round.
on behalf of respondent number.
Okay,
2.
man. No issue, man. Instead of 28, my lord. 27. Could we be happy to 27, my lord?
Huh?
27.
27, but you can't get a hearing on the 27 because it's otherwise a day. 28 is the hearing day.
Then can we have a 29, my lord? When has?
29 is again a motion day.
Okay, ma'am. No issue. 28.
28, therefore I've said, so that I can dispose it of.
Yes, ma'am.
Because that is your final relief, no?
Only that. Right, I understand.
Because that is your final relief, so
I
I have to
understand.
dispose it of.
But lordship, in the affidavit of poison which I received, there are lordship, how, there are annexing A to E. In all this notice, there is not a single line indicating
No,
that there is no.
That I've seen it,
Yes.
that I've seen it anyway. Because here, if you, madam, you kindly look into it, the order which I passed on 24/9/2025. The learned counsel appearing on behalf of the petitioner had made a categorical submission that as regards the termination, if he has any grievances, he will go to the arbitration. It is only on the concept or question of blacklisting, this is the issue.
Yes.
Okay, so we are not concerned with the other aspects.
May
Anyway,
respondent number
Ms. A. Gayan appears on behalf of the respondent, all the respondents. An affidavit in opposition has been filed by the respondent number 3. On behalf of the respondent number 2. It admits that she has received instructions and would be filing an affidavit. Taking into account that the issue involved herein is as to whether the blacklisting proceedings, the order of blacklisting which is impugned in the instant proceedings is in consonance with the principles of natural justice, that is providing the petitioner a due opportunity. This court fixes the matter on 28/10/2025 at 2 p.m. for final disposal. In the meantime, the respondent number 2 shall bring on record the stand by filing the affidavit on 24/10/2025 and more particularly indicating as to whether any proceedings were initiated prior to passing the order of blacklisting against the petitioner by giving the petitioner due notice. It is made clear that the petitioner had at the outset stated that the issue as regards the termination is not being raised in the instant proceedings. And the only issue which remains to be adjudicated is as to whether the blacklisting is in accordance with law. List accordingly.
What's up?
You keep this copy.
Yes, sir.
The registry shall bring on record the affidavit filed by the respondent number 3.
Admission item 6.
Yes, what is this?
My lord, as per order dated, my lord, 27/9/2023, your lordship, we approached railway, my lord, for settlement, out of court settlement, my lord. But till today, we have not received any communication from railway, your lordship. Otherwise, the issue involving the present repetition is, my lord, whether, my lord, unilaterally terms and condition of, my lord, contract be changed or not, your lordship. What has happened, your lordship? We are engaged in, my lord, signal.
What is the unilateral let?
My lord, in fact, here what has happened? We enter into an agreement that your lordship will find it, first agreement, my lord, page 23.
Now, what has been, what has happened now?
My lord, what they have done, my lord, they have reduced the contract price, my lord, unilaterally. As per the contract, my subsidiary contract, the contract price was 8 crore 4 lakhs. But what they have done, they have reduced to, my lord, 7
Contract
crore.
for what?
My lord,
Contract for what?
contract for my, it is a contract for signaling purpose in railway, signal. My lord, it is for my design, supply, installation, testing and commissioning of electronic interlocking system conforming to RS.
Understood.
My lord,
So the amount which have been there,
my lord.
it was a particular contract for a particular period of time.
My lord.
What was the period of time?
But 120 days that I have completed.
Then now you are asking that it should not be less.
My lord, after completion of work, because my.
They have reduced the amount.
Exactly, my lord.
Why you are not going for arbitration? Why should this court look into all these things?
Arbitration, my lord, after 7 years, my lord.
So what? It has
That-
not yet been admitted.
Otherwise, it's a question of law is, my lord.
Yes, obviously, because you have made it freshly new with the
My lord,
2023.
Prima facie, my lord.
Go before the arbitration.
My
Why-
lord,
how can this court decide whether it should be less or more?
No, but the law is, my lord,
There is no law.
unilaterally contract cannot be changed, my lord. It has to be.
Unilateral cannot be changed. It is they will look into it.
Not
That
in
the
terms of
arbitration
unilateral.
proceedings. There's an arbitration proceedings. No.
My lord.
Yes, yes, yes.
There's arbitration. Go
But
before
it's
the
not-
arbitration.
It has not been done unilaterally, my lord. He was issued 3 notices to appear before the railway authorities for a reconciliation. He did not appear. Ultimately, they had to take an expert.
Where? This is under 62.
My lord,
No.
63, page 70,
Where's the arbitration clause?
page 71, my lord.
Arbitration clause. that
34.
Of the contract, they have not.
Page 71, my lord.
It's under 64, general conditions of contract.
Close, serial number 34.
Arbitration settlement shall be
Is there,
governed by
madam?
63 NE. Oh, go there.
My lord.
Thing is there.
Page 71.
Go there. We did exclude the period during which the matter has been pending from 2018. Heard Mr. A. Goyal, the learned counsel appearing on behalf of the petitioner. Mr. B. Sharma, who appears on behalf of the railway authorities. The present petition has been filed by the petitioner being aggrieved by the actions of the respondent authorities. Of reducing the amount to which the petitioner is entitled to.
My
For the contract which the petitioner had completed with the due satisfaction of the respondent authorities.
And completion certificate was also given.
Repealed order.
Mr. You do one thing. You consider his case. As he says this to be an ex parte decision. Let him submit a representation to that effect and you consider within 1 month.
Should pass directions.
I think that is a better option.
My
It is the specific case of the petitioner. That as per the contract agreement, the petitioner had to design, manufacture, supply of solid state bracket electronic bracket close interlocking system, which included 530 numbers of function oblique bit, and price for each individual bit was fixed at rupees 51,950. And therefore, the total price on account of supply of 530 numbers of bit was fixed at rupees 2 lakh crores 75 lakhs 33,652.
additional.
It is the further case of the petitioner that the contract agreement which was entered into by and between the petitioner and the respondent number 3. The work had to be completed within 120 days from date of acceptance of the letter of acceptance, issuance of the letter of acceptance. And the contract agreement, value of the contract was fixed at rupees 6 crores 16 lakhs 37,725.34. During the completion of the project, during the execution of the project, it was found that as per the design approved by the office of the respondent number 3, there was an excess of 195 function/bit hardware system kata for function/bit of about 195 in number would be required to complete the entire project as assessed by the respondent number 3/ the site engineer. And accordingly, the petitioner supplied the additional hardware system required to cater the additional function/bit. In that view of the matter, a subsidiary agreement was executed by the parties on 8/7/2016. And in view of the subsidiary agreement, the original contract price, which was fixed at rupees 6 crores 16 lakh 37,725, was increased to rupees 8 crores 40 lakhs 5,226. The petitioner received an amount of rupees 7 crores 68 lakhs 94,000. And the balance amount of rupees 71 lakhs was pending. It is the grievance of the petitioner that the respondent authorities, more particularly the respondent number 3, had finalized the statement, finalized the dues of the petitioner at rupees 7 crores 64 lakhs 52,655 ex parte. And the petitioner was asked also to sign another document accepting the ex parte decision, which the petitioner refused, isn't it?
My lord.
And approached this court. This court duly takes note of that in terms with the term, as per the terms and conditions entered into by and between the petitioner and the respondents, the disputes are arbitrable in nature, there's an arbitration agreement in clause 34 of the terms and conditions of the contract, which refers to clause 63, 64.1 to 64.7 of the general conditions of the contract and the standard special conditions of the contract of NF Railway 1998 edition.
2024, 14 edition.
This is here, 1998.
This contract.
Subject to any correction made prior to the opening of the tender. Therefore, it is seen that the dispute in question is arbitrable in nature. This court have heard the learned counsels appearing on behalf of both the parties. And as it is the specific submission made by the learned counsel appearing on behalf of the petitioner that the said decision was taken ex parte without the petitioner being made privy to the without the making the without making the petitioner aware. It is the opinion of this court that the petitioner should be given an opportunity to submit a representation before the respondent authorities, more particularly the respondent number 3. Agitating the grievance insofar as the ex parte, alleged ex parte reconciliation of the accounts Mr. Abe Goyal, the learned counsel appearing on behalf of the petitioner submits that the same would be done within a period of 15 days from today. Considering the above, this court directs the respondent number 3,
2 and 3, my lord.
respondent number 2 and 3 to decide on the representation to be submitted by the petitioner. If filed on or before 24th of November 2025, within a period of 60 days therefrom. It is further observed that in the circumstance the petitioner is aggrieved, the petitioner can take resort to clause 34 of the terms and conditions of the agreement. Accordingly, the petition stands disposed.
Deeply obliged.
7.
May it please your lordship, here, lordship, grievance of the petitioner has been resolved, lordship. I've been instructed that it has been resolved, settled, so
So and so appearing on behalf of the petitioner submits that the grievance of the petitioner have been duly redressed, and as such, the petitioner would not like to press the instant writ petition. Accordingly, the writ petition stands closed. Mr. Vidas
For a petition.
appears on behalf of the petitioner.
obliged.
8.
Engineering. D. Mojumdar. What is this?
He's coming. Here, my lord, the petitioner company was declared non-performers by
You are doing it. Will be doing it.
Oh, he's doing my language.
Yes, what is the matter about Mr. Mujumdar?
Hello, here. The petitioner was awarded a work order for construction of road by the NHIDCL. Now, towards the end, after achievement of about 70% of the construction matter. Initially.
What is the impugn order of 4-5?
Declaring me as a non-performer.
That has been stayed.
Yes.
Okay. On the ground that there is no reasons assigned.
Yes.
So if there are reasons assigned, you have no problem. No, you may have a problem. That's a
Minor.
different thing.
Yes.
But your basic grievance is that without there being any reason assigned, you could not have
Absolutely, my lord.
given you a tag of non-perform.
Yes, my lord. Because
That's it.
Absolutely.
Lordship, in this matter, Mr. PG Sikka is appearing, lordship, he is on legs, lordship.
Okay. Taking into account that the respondent, Mr. PJ Sekia, taking into account that that Mr. PJ Sekia, the learned senior counsel, appearing on behalf of the NHIDCL is not available today. List this matter on 9th of December 2025. First of the interim order passed earlier shall continue. On the next date, an attempt shall be made to dispose of the petition.
9.
Lordship, can it be this? Early lordship.
Right.
Sorted lordship.
You are, because of you, the matter got
Right.
adjourned and you want it.
Right.
We'll have it in the month of January. 9th of, 8th of January. When do you want? 9th of December, good day. Next.
Please, my lord.
Who is appearing?
My lord,
On payment of dues.
yes, my lord, non-payment of dues, my lord.
What department?
Irrigation department.
Have they filed affidavit?
Yes, they have filed an affidavit, my lord.
What
Out
do
of
they
20
say?
lakhs, my lord, 9 lakhs we have already received. There is a state share. So, my lord,
Huh?
state share, according to the affidavit, my lord, we have received a state share that is in page number 36, my lord, of the affidavit in opposition.
Do they admit the amount?
My lord, there is a report.
Is the central government a party?
Yes, no, my lord, that's, I pray for some time to implead them, my lord.
Have you impleted?
Not yet, my lord.
Why?
My lord, I have impleted it for the first time, my lord,
Okay.
as per the affidavit, additional
Is the
affidavit. they filed.
matter after the implement application is filed?
Same, similar prayer from next item, my lord. Similar prayer for item number 10 also.
Then also.
Obligation.
Non-payment of dues, your lordship, in amount of rupees 53 lakhs 38,876. By way of affidavit filed on 10/9/2025, they have admitted the amount, your lordship. Page 31, annexure 1 of the affidavit filed on 10/9/2025.
What do they say?
The statement, they have annexed the statement showing the quantity supplied and the amount due to be paid to the petitioner, exactly the same amount, your lordship.
53 lakhs 38,876.
Exactly, your lordship.
Well,
But by the earlier affidavit, we pray for 10 months time to clear the date.
I'm giving you 6 months. 6 months. You 6 months. Take on affidavit consigned, but we have duly admitted to late affidavit consigned. 6 months. Disposed. The date certified copy is given to whom?
Respondent number, District Agriculture Officer, respondent number 3.
Yes.
Well,
Respondent number 3, the DO, District Agriculture Officer.
Ah, done.
Yes.
What is this? Sharma Learned AFDC is not aware of the facts of the case for which he seeks for trial. So produced by UDAS, here is kept on record and marked video, taking into account the matter in the meantime, Safwell takes it, carrying out the demarcation.
The demarcation was to be done, my lord. Earlier circle officer C was arrested, my lord. New circle officer, my lord, officer CF.
The circle officers are getting arrested right, left and center. What is wrong with your government? Why is he arrested? Personal reasons.
Arrested on corruption charges.
All right. Is the MCT appearing on behalf of the respondent? Appearing on behalf of the district administration 6 for some time, taking into account that the earlier circle officer, Goraima Revenue Circle, have been arrested. And the demarcation is only scheduled thereafter, and the new incumbent circle officer have scheduled the demarcation on 27/10/2025. They say instruction is kept on record and marked with the letter X. List the matter accordingly on 24th of November 2025 for an update.
13.
Yes, Mr. Roy Chaudhary. What is your matter?
My lord, I am a president of a managing committee, my lord.
Caveat and said that he has some personal leave today to appear. You are the caveator.
Malad, before my senior start, Malad, this is a bench two matter, Malad. I think this is wrongly been listed.
What?
Bench two matter, Malad, this is.
Don't go by these benches. Benches are something for those people. If the matter has come up in the list, so list has. What do you want? Set aside and quash the impugn order dated so and so issued by the director or hiring.
Well, the rule provide if I have to remove, I have to show.
Have you filed the affidavits?
I have filed today only, Malad.
You filed the affidavit
This
today?
one, I have given,
It has been submitted, respond number?
I'll, for higher education, Malad, I'll prepare for 1 and 2.
What is 1 and 2?
Sorry, Malad. I have filed affidavit.
Commissioner Smith.
Okay. It has been submitted that the respondent numbers 1 and 2 has filed an affidavit. Full stop. Only today. Full stop. Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner submits that he would obtain instruction as to whether any reply is required to be filed. And if necessary, the same would be filed. List the matter on 26th of November 2025. In the meantime, liberty is given to the petitioner to file the reply. In addition to that, the other respondents are also given the liberty to file their affidavit in opposition on or before the next date. Full stop. The interim order passed earlier shall continue. Till the next date.
14.
I have for the respondent number 4, bracket paragraph 4. Copy has been served on us.
I'll give.
No, copy has been served on us, which I.
Not me, Malad. Respondent has not.
Provide, Malad. I have given the
I
copy
have
to
served copy on the very first day. The affidavit has not been served upon the respondent number.
Affidavit, I am speaking of the affidavit. only.
He is supporting your cause.
I'll give, Malad.
May I please?
This is for non-payment.
But different manner, the admitted amount is my lord 7,96,000.
No, 8 lakh.
No, that is.
As per your affidavit.
Page
notice,
28, my lord.
Huh?
Page 28 of the affidavit, my lord.
Highway amounting to.
Yes.
Yes. Second paragraph, my lord.
Well, then the higher charges. Yet to be sanctioned, my lord, yes, last paragraph. Yes.
How much you are asking? 854.
868, I have.
But they admit 854.
Admitted is 50. All right.
854 to allow gold. It will affidavit fit up paragraph 10 to 54. They have filed an affidavit pursuant to the and accordingly so and so are directed to pay the amount of it within 6 months.
Respond number 4 and 6.
4 and 6. Who is it? Police?
Malad.
Police is DGP.
Normally Inspector General of Police deal with this.
No. DGP, if it is given, he does to everybody. DGP is there or not?
Yes, Malad, they are,
The
but
respondent-
normally next to
Direction is given
DGP deal this.
Upon certified copy submitted, all the respondent numbers, all the respondents are jointly and severally liable for making the payment. So the respondent number 3, upon certified copies out of only 6 months.
That normally 3 months, I mean,
Make it 9 months.
Malad, beg
Six.
apology, Malad.
15.
Malad, 16 also same, Malad, admitted amount, Malad.
Affidavit filed.
Malad, 16.
15 participants.
Malad, next.
Item number
Malad.
15. 15 is different matter. You are not there.
And 16 and Malad.
We are not going to take up your matter then 16. Yes, what is this? P. Sharma appears on behalf of the case of the petitioner. Herein is the petitioner was settled with so and so for a period of sale. The petitioner sought for remission of certain amount on account of disturbances causing a man. However, I have not considered the request. Yes, affidavit filed.
File, Lordship, file, file affidavit.
Who has filed? You have filed affidavit?
Lordship.
Where is it?
District Commissioner have filed affidavit.
Where?
On 17/10.
This case is of
Today,
Samhita Das.
Today we have filed.
You have filed the affidavit today. Mr. B. Gogoi appearing on behalf of the Fishery Department.
No,
What is-
I am for the government. Beside P. Soma,
P. Sharma is nowhere.
he is not well. Lordship.
Huh?
P. Soma is not well. Lordship.
Not well.
He is Delhi sorry for treatment.
Oh, okay. So you appear for all.
Also today I can
Mr.
appear for.
Sharma, Mr. K. Gogoi appearing on behalf of the respondents have submitted that the district administration have already filed an affidavit in the instant proceedings. So Sapnal has appeared on behalf of the petitioner on call. List this matter again on 15th of December 2025. Liberty given to the petitioner to file reply if any.
16,
The registry shall bring on record the said affidavit filed by the district administration. Yes, affidavit filed.
On the paragraph, page 25, paragraph 5, ma'am. 6, ma'am. 6. Six and 8.
Paragraph 6 we could go in, huh? But let's suppose 6 months.
Hello.
17,
My pleasure, Lordship.
We have filed affidavit with the Lordship.
We have received the copy today itself.
What affidavit?
Yes, opposition.
What do they say?
They are just saying that about only one para about latches, delay and latches.
Huh?
Not maintainable on the ground of delay and latches, as the petitioner is in the writ petition have failed to explain this.
Lache.
Yes, sir.
Okay. So this is for which period?
It is for the period 1819.
1819.
Yes, sir.
They are raising the issue of delay in latches.
Yes, sir.
Yes.
The last quarter also Lordship observed that.
But here they have duly admitted, this executive officer, Nalbari, well, they admit this amount. They are not denying the amount.
No, so nothing about the denial of the amount.
The affidavit has not come on record.
Yeah, they have filed
Not
today.
yet, not filed today on.
You have filed today. Ms. So-and-so submits that the affidavit in opposition has been filed. Established this matter again on 3rd of November 2025. The registry shall bring on record the said affidavit.
18,
Deeply obliged.
Non-entering into an agreement with the petitioner despite issuance of letter of intent in extraction.
We have received the instruction, Lordship. There's a DSR report awaiting. We need to, there's a DSR report, a district survey report, which has to be given by the district authorities so that, as per the.
Mining report?
We will be filing
Plan?
affidavit. We will be filing an affidavit. We received the instruction, Lordship.
You have received the instructions. You're filing the affidavit
We're filing it within a week, Lordship.
next week.
Next week.
Okay. Mr. R. Gogoi appearing on behalf of the Excise Forest Department submits that he has received the instructions and would file the affidavit. List this matter on 10th of November 2025. In the meantime, the affidavit be filed on or before 4th of November. Liberty given to the petitioner to file any reply.
19 and 20.
Yes, what is this?
So this is, I could not go through it, my lord, the entire petition. But this is about demolition. There was some order passed by the court to carry out demolition of 4th floor is concerned. And the first floor also, the ground floor has been cleared and the as per instruction of my client, the demolition has already started, 4th floor. Third floor, there was also an order of the court. One portion we occupied, one portion has been rented to another person. Now, there is a complaint which was filed by one Sanjay Sharma, who is also an occupant where we have built that entire construction was done by us and one portion was sold.
Who are you? Jahidul Islam?
Yes, I am the owner of the land and where I constructed entire building. Now there was a complaint of one of the occupants, Sanjay Sharma. He makes a complaint He makes a complaint that there is, the problem started with the parking. The parking is not given. So there was some complaint and ultimately notice was given. So we have cleared the parking, we cleared the entire thing. Fourth
You
floor
are the
is,
builder.
I am builder and owner of that land, my lord.
Now the construction is being demolished.
Demo one for the fourth floor, we have given undertaking that we will
Has
build
it
it.
been demolished or not?
Yes, this is started. It started.
What started? It is going on for such a long time.
Yes, it
Last
started.
time also it has been all along from 1/8/2000.
My lord, the
1/8 at least this matter for an update as to
sir.
whether demolition has been carried out as per the orders passed by the Commissioner GMC. 22/5 exposure the learned council on behalf of the submit that demolition is going on and will be completed in a week's time. It has not been completed.
No, this is an
Ultimately, responsibility was given.
Given
They
to
have
us,
not-
my lord.
They given undertaking that we are going to demolish.
No, you do one thing, you demolish it
Okay.
and put the bill upon them.
No, we have
Wait.
already started. We started, my lord.
No, this is not done. This has
Started.
to be demolished. Demolish and put the bill upon them.
That is all, that order is also page 95 of my.
Oh, then go ahead. Demolish entire building.
Entire building,
Moreover,
where I will see.
Just
Then the entire building, then only.
Not
he was
entire
the
building.
builder.
Huh?
He was the builder.
For that impose huge.
He has
cost upon-
already constructed.
There's some stay also.
Stage not.
Huh?
No, that we have to call.
Considering that the petitioner's grievance for regularization of it has been rejected by the EA and finally by the impugn order, and also consider related matter is pending before this court to demolish, and that some part of the ground floor have already been demolished, till the returnable date, the impugn of the mayor in council shall not be given effect to in respect to the third floor. There's a stay.
No, on that point, lots of it can be seen. Two paragraphs, now, 6 and 7, Supreme Court.
Vera?
6 and 7.
The learned counsel for the petitioner would submit that her client has been given one chance to pray for regularization of the unauthorized. We do not find any merit in it. A person who has no regard for law cannot be permitted to pray for regularization after putting up unauthorized construction of 2 floors. This has something to do with rule of law. So therefore I'm saying, not third and fourth, demolish first also, first, second also,
Permission was.
then they will realize. An
Permission was
unnecessary
grounded
construction.
to law.
And then let those people whom they have sold, these people should be asked to get the money from them. That is also an order to be passed. This is not done, absolutely illegal construction.
2025.
You should have constructed in a government land. They would not have done anything.
Why?
Are you aware of that? The GMC and the GMD does not take action when a construction without permission is done in a government land.
Of course.
Isn't it?
That's a.
That I recorded yesterday in an order.
That's I don't know, man.
This is an information for all those people who indulges in unauthorized construction. The GMC and GMDA does not do anything if you are constructing in government land.
But own land,
Own land you have problem.
then I don't have to say my God.
Own land you have.
Lots of this is, he is the builder. He constructed the building, he sold the building. Now thereafter, he is not the owner of that plot and that building lot. How can he play for regularization? It is the occupants of that building who are owners of the flat. They can pray for regularization. He is no more the owner of that.
My lord,
plot
if
and
it is,
plot and-
my lord,
Regularization cannot be given at all.
Yes.
Question of
My lord,
regularization does not exist.
my lord, if it is not, but if it is not inconvenient, my lord, if it your lordship can accommodate Wednesday, let it come, my lord. I have not gone. Wednesday, your lordship will take a call, final call. Let it be on Wednesday, my lord.
2 floors, 3 and 3rd and 4th.
Third and fourth. Okay, you give an update, how much construction has been demolished.
Yeah.
And if it is not done, then I'll pass an order by which you can recover it as land revenue from
Land
him.
revenue.
From him. And demolish from ground floor also. Ground floor, first floor, second floor, and give them an empty block of land again to make construction.
We cannot collect revenue from him also, because he is not the owner now.
No,
That has already been.
no, not for that land.
Yes, for some other.
It will be taken, you'll be initiating Bakita proceedings. When it is meant by you'll collect it as a penalty from a land revenue, it is a Bakita proceedings by which you can attach any other land he has, any other land, any other bank account he has. You do that.
But for your information, I have learned today, when it is a government land, so you construct that, I'll keep it in mind.
No problem.
I'll keep it in
I
mind.
have recorded it in an order, yes.
That's why I should get that copy of the order with me.
you
Always I'll keep that
You
order.
ask, Mr. Yusuf Manan is the lawyer there.
I'll keep it with me then. It's,
Yesterday it was
it'll be-
item number 7.
my lord, not in this case, some other case, it will be very easy. Your lordship will take care of
Okay,
it.
we have it on
Yes,
that
yes,
day.
yes.
List
I'll
the
be clear.
matter, list the matter again on 22nd. We finish it off on 23rd.
23rd, my lord.
23rd at 2 p.m.
2 p.m.
On which date an attempt shall be made to dispose of the petition. More particularly taking into account the judge directions passed of the observations passed by the Supreme Court in the case of Kaniz Ahmed versus Sabuddin, reported in 2025 INSC 610. First up, Mr. P. Naik shall apprise this court as to and as regards an update as to how much construction, as to whether the demolition has been completed, demolition proceedings have been completed.
The judgment of High Court, Priyanka Estate. That judgment.
Priyanka is for
Priyanka-
those persons to get the money from.
Priyanka Estate. Deeply obliged, sir.
Oh, yes. What is this?
In item number 21, Lordship, with after an order by this court, Lordship, we are allowed to participate in the process, Lordship. And since then it appears that the process has not yet concluded, Your Lordship, the selection process, technical evaluation will take some time, Your Lordship, which is reflected in the last order.
Why did you file this petition?
To allow us to participate, Your Lordship.
Why?
Because they have put up a clause, Lordship, which states that if there has been any history of any structure demolished, constructed by us within the last 3 years, Lordship, that becomes and that disables us from participating, Your Lordship. And to that effect, Lordship, an extent order of the High Court of Patna, Lordship, whereby they have absolved us of any responsibility, Lordship, towards the demolition of the structure. So we believe that we have to believe that that they would have not allowed us to participate, Lordship, if we would have had this history.
Yes. For approaching the court, Lordship, they have already submitted their tender, Lordship. Otherwise, Patna High Court, they have not even the, might not be kindly choose the Patna.
No, have you allowed them to participate?
We participate, the Lordship.
Yes, already he has, before approaching the court, Lordship, he has already submitted his tender, Lordship.
Then
After that, he has approached this court, Lordship. Now our technical evaluation is going on, Lordship. It is in respect to the second bridge in the Brahmaputra, near the Haraigat Beach, Lordship. Rail come road bridge, Lordship. Our technical evaluation is going on. Otherwise, I have received the instruction, I can file affidavit also, Lordship.
you file your affidavit.
Lordship.
It's a long, whole matter.
All matters, Lordship.
How much time?
Within a week, Lordship.
Within a week time. You have taken 2 nights.
Otherwise, Patna High Court, they have take own responsibility for collapse of that particular piece, Lordship. On that regard, it was closed, Lordship. They have not given the clean sheet, Lordship.
Are you making this bridge?
The second bridge, Lordship, the second bridge, Lordship.
This one they are constructing, Lordship.
Which one? The new one with the arcs?
Lordship.
You are constructing.
Name by changing the name after collapse the Patna, this Lordship, they have changed the name, Lordship.
Oh.
Well, SP Singla, Lordship, we have been awarded the majority tender.
They have changed the name, Lordship. Now, earlier name was not there,
Oh, now you are appearing for railway.
Lordship.
Or the state of Assam otherwise has no problem with them.
Lordship.
But you, as a railway, you don't want to give them.
Lordship.
Okay.
Only Lordship, we are suffering lot in the Patna also.
Yeah, Bihar also.
But how is Mr. Ken Chaudhary making a case, making submissions on behalf of this client? Being the president of the bar? Isn't it one of his contentions everywhere? Saying that this bridge may fall down for the High Court?
Lordship, this is Jogi Khopa, not the Lordship.
No,
Jogi
this,
Khopa.
this bridge who is making?
This one, Lordship, not us.
This bridge?
Where's Jogi Khopa?
No, are you not making this arc bridge?
Lordship, this is not the railway, it's the railway bridge, Lordship.
We are concerned with this bridge.
No, Lordship, new bridge was also Lordship, near Lordship Agiaturi.
That is ours.
No, no, this bridge which
This
is
bridge
coming
was
up.
constructed by them by changing the name, Lordship.
This is what na.
Changing the name,
That is
Lordship.
why I'm saying.
Changing the name, Lordship.
Isn't he saying everywhere?
Our allegation is that.
The person concerned is making a bridge which may fall down on outside, and now he's appearing for this kind.
That piece also, if that new piece also completed, that we will be also that particular piece, Lordship.
My goodness. This is girl. What is the difference when you are professional and personal?
Even after that, in the Tamil Nadu also Lordship of contract was issued in respect of, and that particular company we have not allowed it.
It's okay. Now they changed the name
Changed
and
the
one
name,
party.
Lordship. After collapse of the Patna, they have changed the name. Lordship.
So if I dismiss his petition, then I'm putting some fuel into the Bar Association's hesitation.
Lordship.
And if I allow his writ petition, then it is putting your bridge at risk.
Yeah, but this bridge is different, your Lordship. This bridge is Jogi Khopa,
Understood.
Lordship.
After all, there is a bridge to be
Lordship,
constructed.
Lordship.
Okay. Mr. K. Gogoi, the Learned Counsel submits that he has received the instructions and would be filing the affidavit in a week's time. Lists the matter on 12th of November 2025. In the meantime, the affidavit be filed by on or before 3rd of November. Liberty given to the petitioner to file reply, if any.
Lordship, could it be a week later, Lordship, around 18th, your Lordship?
Why?
There's some, the outstation council will also appear, Lordship, he has some
They will
difficulty.
throw BC, Lordship, no issue.
No, let it be on 12. Whether I will be there or not, anybody else may be there. On Wednesday, nobody takes up matter for disposal.
Lordship.
Oh, Mr. Ghosh, your matter.
Lordship. Yes, supposed to file.
Affidavit file.
No, I'm not.
Regarding these instant writ petitions, we have we have prepared our affidavit and we have sent it for vetting. As per the last order, where we had to submit, where we had produced records, we have received those too. But however, today Lordship are praying for some accommodation on the grounds that Mr. Bigoga is on legs. We have received all the records as well as Lordship.
Have you filed your affidavit or not?
No.
You're not going to file the affidavit.
No, Lordship, we have sent it for vetting. It will be filed by next week.
Mr.
And we are Lordship.
MV appearing on behalf of the PWD submitting that the affidavits have been made, have already been prepared and will be filed positively by next week. List this matter on 29th of October 2025. There's an interim order passed, na?
Yes, my lord. That my lord is subject to outcome, my
It
lord,
is subject to.
of all the possibilities. It's 8/9/25 order, my. Look, doesn't-
No, there is some interim order somewhere, no?
5228, my. 5228. What are I saying? You can well.
Oh, you did not participate.
Yes,
na?
yes, Lord. Yes, Lord.
But this writ petition has become infructuous, 4799.
4799, my lord, we have
SL, my lord, the retender notice, my lord. Without assigning us any reason, retender notice was
So
issued.
that
my
is in 5228.
That 5228, my lord, in 4799, lordship has passed an order.
That without any reason has
Yes,
been
so
given.
directed then to furnish the reason.
Reason.
And give us a liberty to assail this if when the reason is.
So you have assailed in 528.
Yes, my lord.
So therefore 4799 has become infructuous.
My lord,
Because you did not participate.
Yes, my lord.
You did not participate. Anyways, it has been submitted by Mr. M. Bhuyan that the matter affidavit be filed. List the matter on 14th of November 2025. The affidavit be filed on or before 31st of October. Liberty by on or before 4th of November. Liberty given to the petitioner to file any reply.
24.
Thereafter. Mr. Pasa, Mr. Hawk.
My lord, on last occasion, my lord, the forest department was directed to file their affidavit, my lord.
Lordship, there is a pending NGT case against this Bridgestone, your lordship. There's a and there is no whisper about this case, your lordship, in this.
Phone to case, huh? Phone to-
Pasa Stone Crusher Unit. For alleged violation of the rules.
Who should they have violated? my lord? Pasa Stone case. my lord.
Yeah, Pasa.
Yes, Pasa construction, my lord, it is.
Pasa Stone Crusher.
Yes, my lord. But here's another stone case. Probably it is village to that, my lord. Come to village, the system. Both are. It is written. Very stone case as well. That's right, like that.
It's okay, this is the notice being issued.
Yes.
You must have appeared. Because it was returnable on 7/5/2025. And what is your stand apart from this?
This little matter being sub judice, we are not going ahead with the renewal, lordship, because matter being sub judice before the NGT, your lordship. That's why we're not going with the renewal. Certain allegations have been raised against.
My lord,
two-
that is separate, my lord. It is separate, my lord.
Huh?
My lord, petition had two stone cases, my lord. That NGT case, my lord, that is instituted, my lord. That had yet not been operated, my lord. It is separate, my lord.
This is Pasa Construction.
Pasa construction, my lord. It is separate, my lord.
Purvakatra village, your lordship, at Annexure B, page 15.
And this Pasa Construction is at
Kundrakotara village.
Kundrakotara,
And that is.
Yes,
Nalbari. And here it is
Chengnoi.
Sengai Kundrakotara
village
village.
here Nalbari, village Sengnoi.
Sengai
And this is village Kundrakotara. So this is a different one.
Kundrakotara village.
Pasa Construction is good. This is stone crusher unit. Anyway, you take your instructions. We'll have it next week because you have not given it. List this matter again on 29th of October 2025. In the meantime, Mr. R.R. Gogoi, the learned counsel appearing on behalf of the Forest Department shall bring on record its stand by filing the affidavit on or before 27th of October 2025.
My.
25.
Issue out here is why you are not extending it.
Extending.
That's it.
Obliged.
Yes, that is great.
affidavit, lordship. It's 175, lordship.
They have yesterday,
We
your
have
lordship,
filed affidavit in opposition, lordship, whereby page 175, oil has already passed a speaking order.
May I just-
putting the petitioner.
the
Holiday
great
days for-
petition was filed, my lord, on the last occasion was in regards to a suspension. In terms of that, my lord, they had also in the same note, in the same show cause has also show caused me for the banning.
So you have filed your affidavit.
Yes, sir.
I received it yesterday, I filed it yesterday.
You
In
want to file
regards to,
reply?
yes, I'll have to. And subsequently, my lord, after the passing of your lordship's order, where we had come for suspension in the present contract, they have now banned us maximum 2 years period. That is for all future contracts. So I will have to first put in a reply to this because there are a lot of allegations been made in regards to certain cases pending, which I'm not aware. So I need 2 weeks' time.
And perhaps in regards to the banning also, I might have to file a separate petition. because
Another.
That's, there's an order been passed. now, so-
This one has become impressive.
No, it may not be, my lord. I tell you why.
No, let him file his
Yes.
reply.
Yeah, at least.
So the respondents have, respond numbers 1, 2, and 3 have filed the affidavit in opposition 16/10/2025. Mr. R.B. Pukon, appearing on behalf of the petitioner, submits that he may be given an opportunity, the petitioner would like to file a reply there against. List this matter on 7th of November 2025. In the meantime, the reply be filed on or before 4th of November.
Extremely great. Extremely.
We'll have it
Supplementary
on
item 49.
November, 10th of November, you file by 7th of November.
10th of November. Extremely great.
May I please your lordship. My lord, the 49 and 50 are similar matter, my lord. Here, the writ petition have been filed for not releasing the security deposit money for the last 9 years, my lord.
Understood. It appears the petition entitled to refund of the security is not denied. It however appears that on account of certain payment not being deposited, under the head of account number, so the security deposit could not be released.
I mean, in this regard, my lord, not only of the petitioner, some other liabilities are also there, my lord. The review meeting was held, and this is the, my lord, instruction that I have got. In both, same instruction in both.
Okay, so here, this is for what purpose?
It says, my lord, all pending liabilities. Because we'll have to refund the amount.
Huh?
We'll have to refund the security deposit, my lord. They say that, my lord, whatever liabilities there, they will verify the final, in the final review meeting, and then it will be released within a period of 3 months or so, they have said.
But this, he is entitled to when? Claiming this amount since when? 2015.
No, 15 was the work, my lord.
Work completed.
Work completed, my lord.
So you pay the interest also included at 9%?
But let them, my lord, the authorities first take a call.
No, you cannot do that. He has completed the work. You have not filed the affidavit. He has completed the
Last
work,
time
you
I
have
placed the
not.
instruction, Lord Civil directed me to have instruction regarding the, specifically on when it will be released.
Yes.
That's why, my lord, the affidavit was not filed. Otherwise, I got the pairwise comment.
No, you cannot say that. The amount is admitted. Why you are not releasing his, he is only asking for the security deposit. He's not asking for anything else.
My lord. Only security deposit, my lord.
Give a direction and the time frame, they will make the payment.
With interest
That I leave it.
from 2015 up to 9%.
No, it cannot be from 2015, my lord.
15.
My lord, it was to be
You
released.
have not filed the affidavit also.
The affidavit, Lord Civil said,
Complete
my
the
lord, we have the
contract
instruction.
of the month they have not been released. This is his statement. I said on the earlier occasion, one earlier order on the doctrine of non-waiver.
My lord.
Entitled to the security or not this court taking into account the doctor shall pass appropriate orders.
No, Lord Civil, already on the last occasion, I placed the instruction, man.
Yes.
Pairwise comment and all.
So you
Lord
have,
Civil
you
said
say that he's entitled to.
yes, it is there in the instruction. I
love
So
placed
you
it for
pay
not-
within 1 month.
That Lord Civil, that's for direction, man.
Huh?
They will have to comply with whatever Lord Civil passes. Because it is not disputed. The amount, but figure may not change, but that's a different issue.
No, they may verify, my lord. Exact amount, my lord.
Huh?
They may verify the exact amount, my lord, and they may release, my lord.
What is the exact amount?
My lord, in item number 49, my lord, it is 41,74,300 rupees, my lord. And in item number 50, my lord, it is 27,25,344 rupees, my lord.
Security deposit. Huh?
My lord.
And these are the instruction on the basis of which the earlier order was.
Wait. This court, pursuant to this court by an order dated 25/9/2025. Directed the respondent authorities to place before this court as to when the security deposit of the petitioner would be released. It is pertinent to mention that the respondent authorities duly admit that the petitioner is entitled to the security deposit as claimed in the petition. The fact that the petitioner had completed the work and was entitled to the refund immediately thereupon, as per the terms and conditions, is also not denied. Considering the above, however, today, when the matter is being taken up, Mr. B. Gogoi, the learned standing counsel of the PWRD, places before this court, there's some committee, some review meeting is being taken up. As regards social and infrastructure development fund projects. The said plea so taken in the opinion of this court appears to be a lame excuse. Considering the above, this court fixes this matter on 3rd of November 2025. Liberty is given to the petitioner, respondents, to file an affidavit giving reasons as to why interest at the rate of 9% should not be imposed upon the respondents on the amount due to the petitioner. From the date the amount was payable to the petitioner. It is observed that if no affidavit is filed, it shall be assumed that the respondents have no objection to the imposition of interest.
The first of November.
Third question.
Third.
Okay, we make it 7th. File your affidavit, and if you don't, 9%.
Not
50. Well, I don't 50 similar, madam. Item 50 also similar, madam.
Same.
Applies.
You are what? बाकी सब चीज ईमेल ने क्या आइटम okay. Yes, orders, anything extended? Today I have to rise early, na? Anything to be extended? Any interim orders? Dilip Botra.
Lordship, there's one interim.
Huh?
Item number 41, Lordship.
41, what is that? What is that?
Lordship, it's regarding Lordship tender, there was an interim.
Interim is there.
Yes, Lordship.
Service is not complete.
Pardon.
Interim is there, no? Item number 41. Item number 41, anything? You have.
My lord, my instruction is that he is running right now, my lord. A specific instruction is required, my lord, because I'm little bit confused.
Mr. S. Dr. the learned standing counsel of the PNRD submits that he requires some instructions in the matter. Accordingly, list this matter again on 10th of November. The interim order passed earlier shall continue till dawn. The respondent shall also, the registry shall also bring on record as to whether the service has been effected upon all the respondents.
Hello.
You have taken steps now in this
Lordship, yes, we have taken steps and we have filed the affidavit also.
of service.
Yes, Lordship.
Anything else? Any interim order to be extended? No.
My lord, in item number 35, your lordship. Just yesterday we had a difference, your lordship. Kalpana 5, your lordship.
It's okay, there's nothing out there. Any interim order is to be extended or not. Any of the matters? Anybody's interim order to be extended? No. But I'll rise now. Any dates, this item 55, 55 PPS office, 50 date could be. Anybody wants any particular date may ask them.